Zachary Johnson is in custody, and that's going to be a plea.
Yes, Your Honor.
So that's
That's what you say. You can be brought. He can be brought up.
okay.
On the record in the matter of the state of Michigan versus Robert Rawls, 23-02001, appearance, please.
Jeffrey Billaby on behalf of the people, Your Honor.
Good morning, Your Honor. Stephen A. Freeman, public defender on behalf of Mr. Walls. Mr. Walls is present in the courtroom. Just stand.
Okay, Mr. Ross was scheduled for a preliminary examination today, a electronic communication interference. How are we proceeding?
Your Honor, I do not have the necessary victim here to proceed with this case.
Your Honor, this is a 2023 case. In light of the people's inability to go forward, I would respectfully move the court for a dismissal without prejudice.
The motion is granted. We'll get you a copy of this, the dismissal, okay? Thank you.
Thank you.
Okay, on the record in the matter of the state of Michigan versus Diago Benson, 25-02941, appearance, please.
Jeffrey Billaby on behalf of the people, Your Honor.
Karen Robinson, Assistant Public Defender for Mr. Benson.
Okay, Mr. Benson was scheduled for a probable cause conference today. How is Mr. Benson here?
He's not, Judge.
Have you had communication?
I have not.
Yeah, sure, make sure.
Do you consider a 48-hour hold, Judge?
I will.
Thank you.
State of Michigan versus Nathaniel Betts, 25-01506, appearance, please.
Thank you, Your Honor. Good morning, Randall Berman on behalf of the people.
Good morning, Your Honor. Stephen A. Freeman on behalf of Mr. Betts, who is not in the court.
Have you had communication with Mr. Betts?
I have not, Your Honor. He shows an address in Detroit, and we have sent, well, the office sent an actual letter through the mail, and serves me, it either came back not deliverable or something to that effect. Anyway, I've not had any contact with Mr. Betts whatsoever.
That was your bench warrant.
Because I was just informed that Mr. Betts may be in custody in Wayne County, but I'm not representing that as a fact to the court.
It wasn't in jail, so it's inside the file, not on the file. Kind of different.
Judge, just so you know, I handled PCC for that last week. He was in custody here at the time, and he was telling me that he had a case in Wayne County that if he had posted bond, he was going to be taken to Wayne County. What happened to that? I have no idea.
He had $25,000 cash shorty bond. Did he post it? Yeah, it says he posted. I'm finding out.
He is in Wayne County.
He is in Wayne County. Thank you. reset that and read it. Thank you.
Thank you, Your Honor.
Thank you.
State of Michigan versus Anthony Goodall, 25-02487. Mr. Goodall here.
Jeffrey Billaby on behalf of the people, Your Honor. Goodall?
Correct. Here to the record.
Assistant Public Defender John Lee on behalf of Anthony Goodall.
Is Mr. Goodall here?
No, he's not here.
Have you had communication?
I have attempted, but have been unsuccessful.
It looks like he failed to appear for his PSI, so is he already in warrant status? Not on this one. Oh, okay, he's in warrant status on another file. Do a warrant on this one. Thank you. The State of Michigan versus Jasmine Henderson, 25-02572. Appearance, please.
Jeffrey Billaby on behalf of the people, Your Honor.
Good morning, Assistant Public Defender Sarah Donnelly on behalf of the defendant Jasmine Henderson, who is present and standing to my right.
Ms. Henderson, you scheduled for sentence today. I do have a pre-sentence report that was prepared on the 23rd of this month. You got a copy of that, counsel?
I did, Your Honor.
The people have to, Your Honor. No changes or deletions.
Yes, so that we have no need for any additions, deletions, or corrections.
So you can make a motion.
Thank you, Your Honor. Simply put, we'd ask that the court follow the recommendations. Ms. Henderson is currently on a term of probation with Judge Buchanan and with Mr. Nevis already. So his recommendations are reasonable. We ask that the court sends her to a term of probation under the Homes Youthful Trainee Act and to follow all conditions. Thank you.
Is it with Buchanan or Ward?
I'm sorry. Oh, sorry, Your Honor. Yeah.
Your client want to make a statement.
Did you want to thank him, Kristen?
Representation is appropriate. If I'm going to give you Hyder, I gotta put John on probation, and you're already on probation. So long as you're compliant with those terms, that'll make you compliant with this. That's the only order I'm going to make, is that you remain compliant with your probation before Judge Buchanan. So that would be 6 months on this probation trial. We will not need to report on this. I'll make it non-reporting. You're already reporting. I think a $75 crime victim rights fee plus a $50 state minimum cost that will be assessed. I'll waive any other fines and costs. It's $125, okay? You have any questions? Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing from defense. Thank you very much.
You're all set, ma'am.
Yeah. Okay, thanks.
the record in the matter of the state of Michigan versus Zachary Johnson, 24-0242, appearance, please.
Jeffrey Billabay on behalf of the people, Your Honor.
Good morning, Your Honor. Attorney Derek Etheridge from the Office of Public Defender on behalf of Mr. Johnson, who is in the courtroom, standing to my right.
Okay, Mr. Johnson, I have here a plea offer. It says the people are offering for you to plead guilty to use of a controlled substance, that being methamphetamine, under MCL 333.74042A-A. That's a misdemeanor with a maximum penalty of 1 year in custody and or $2,000. The people also agreed to dismiss the second degree retail fraud in file number 24-00564 in the 55th District Court. Is that your understanding of the offer that was extended to you? Do you wish to accept that offer today? Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Okay, you can put your hand down. Okay, you do have the right in this matter to proceed to trial. You have the presumption of innocence. So you're innocent until proven guilty. You can maintain your innocence, to take this matter to jury trial and require that the prosecutor first prove each element of the charge being brought against you beyond a reasonable doubt. You understand that? Can you speak up a little bit more?
Yes, Your Honor.
Okay, and you also have the right to see, hear, or question any of the witnesses called to testify against you, the right to call your own witnesses to testify on your behalf. You can waive your silence and testify at your own trial, or you can maintain silence at trial and they cannot use that against you. You understand that?
Yes, Your Honor.
You wish to give up each of those rights today?
Yes, Your Honor.
Is anyone promising you anything to get you to waive those rights and enter a guilty plea?
No,
Has there been any threats made to you to coerce you to plead guilty?
no,
Are you currently on probation or on parole?
no,
Do you have any other matters pending?
no,
You understand that by pleading guilty, it could result in a conviction that you may need to report to either a current employer or you may need to place this conviction on a future job application.
Okay.
You understand that?
yes,
It also could have impact on travel or immigration status that you may be seeking. So you may want to go out the country on vacation and that could have an impact. Or if you're not currently a citizen, it could flag for your deportation. Do you understand that? So, as to the amended count of use of a controlled substance, how do you plead?
guilty, Your Honor.
Not a factual basis.
Mr. Johnson, I'll draw your attention that August 17th of 2024, where you're at the intersection or near South Washington and East Allegan.
Yes,
That's in the city of Lansing, Ingham County, state of Michigan, correct?
yes,
And at that time, you intentionally possessed methamphetamine, correct?
yes,
You knew it was methamphetamine at the time you possessed it, correct?
yes,
Your intent when you were possessing it was to use it, correct?
yes,
And you did not have any type of prescription or legal authority to possess methamphetamine, correct?
no,
The people are satisfied, Your Honor.
I'll accept your plea. I find your plea to be freely, voluntarily, and intelligently made. Your matter is scheduled for sentencing December 19th at 9 o'clock in the morning. I am going to order that he undergo a substance abuse assessment. He needs to meet with probation so they can prepare a pre-sentence report. He's being held on something else?
No, Your Honor, it's not, to my knowledge, he's not, based on the information I've been provided by him. I do know that he is struggling with his addiction and he wants to go to rehab. I was hopeful maybe that probation will recommend inpatient treatment and he could stay in jail until a bed is available.
Okay, so I'll note that in the file and that probation will make arrangements to meet with him from Ingham County Jail. Any additional matters for the record?
Nothing from the people, Your Honor.
No, Your Honor, thank you.
Thank you, you're all set. We are running Anthony Kristen.
Yes, Your Honor.
He can be brought up.
That's me.
What's going on with Andrew Jones?
Your Honor, that will be another request for adjournment for drug court assessment. Drug court did provide an update this week saying that they met with me Monday and should have the assessment done soon. He did want me to ask the court for a bond motion. He is on parole hold, but he's requesting a PR bond so that the MDOC will have to take action in his parole violation. And I can make appropriate arguments that the court ready.
Wait for a report or just, they're waiting for drug court to do their assessment? To see if he's eligible. to this. December 11th at 9:30. December 11th at 9:30. Give me dates. And then I can have them brought up if you want to address on it.
Thank you, Your Honor. It's a PCC on December 11th.
Correct.
Thank you. I'll walk down the ward and take care of something. and I'll be
Thank
right
you.
back.
On the record in the matter of the state of Michigan versus Evelyn Jackson, 25-02571.
Jeffrey Billabay on behalf of the people, Your Honor.
Sarah Dank on behalf of Ms. Jackson. Ms. Jackson is present in the courtroom.
Ms. Jackson is scheduled for sentence today. I do have a pre-sentence report that was prepared on the 28th of this month. Council, you got a copy.
The people have received the copy, no changes, Your Honor.
Yes, Your Honor, I did receive a copy. Ms. Jackson does have a copy. The only changes, there appears to be some contact information that's not correct, including her social security number. Because we're recording the proceedings, I advise Ms. Jackson to contact probation to make sure that her contact information is correct.
Thank you. And this was information that was, she should have filled out on her questionnaire. So she's saying that she filled it out incorrectly.
There seems to be some transposing of some numbers. from her
Oh,
social
in the report.
Yes, and that's just why, because of the nature of what
Got
the
it.
numbers.
I see that. But what you put on your paperwork was accurate, correct? Is that what you're saying? What you wrote on the questionnaire was accurate?
Yeah, I didn't write it. It was the probation person.
No, we're just saying that when you were discussing.
You see this questionnaire here?
Yeah.
Did you write that?
Yeah.
Okay, council,
Well,
can you
not
have her,
the green
council,
stuff.
can you have her confirm that what's in here is accurate?
Yes. Your Honor.
Close the lady.
Your Honor, may I approach?
Yes. Okay, thank you. That's your pen. Thank you. Now, it's actually different even on her PCA.
Can I write it down?
You may. I'll give you a sticky note. What happens?
Just so you know, Heather is gonna be an adjournment as well as you wanted to handle that as well.
So who?
Heather, counsel and defendant are here.
Oh, Okay, so we have the correct one on her CCH. Okay, sounds good. Thank you. Okay, you can make application.
If you're, I'm asking the court to follow the recommendation of probation department and have Ms. Jackson participate in probation under the height of deferral status. I do think that she's a good candidate, can learn from this incident and not reoffend in front of the court.
Oh, did your client want to make a statement at all? Oh, yeah. you wanna
Yes,
say-
yeah, no. Did you want to say something?
No. Okay, I reviewed the criminal history. I don't see any adult convictions. I think she's a good candidate, or would be a good candidate for sentencing number HYTA. She has credit for 2 days. Bond in her name. The term of probation, they're requesting 8 months. I'm gonna do 6 months. Probation. While on probation, you have the following conditions. You're not to engage in any assaultive or threatening behavior. This was an issue at a traffic stop. Is that correct?
Your Honor, Ms. Jackson came to a traffic stop that was happening with the co-defendant.
Oh, that's what, okay. Let's see. Grant status under HYTA. Not to use, purchase, or possess firearm, ammunition, or weapon of any kind. You're not to use or possess alcohol, marijuana, or controlled substance. You will be required to submit to random preliminary breath testing, and you're responsible for the cost of that. You're not to be at any bars or nightclubs while on probation. Do you understand that? No. You are required to maintain employment and provide evidence of that to your probation officer. So, I still think that you would benefit from some anger management, even in understanding that. Even if you don't like the way you're being spoken to, when you have people in a position of authority, it's important that you understand that that's not where you fight your battle. And so you got to maintain control over yourself and how you present yourself, and even the language that you use to help do your part in de-escalating the situation. You understand that?
Yes.
So that's 6 months probation. There's a $75 crime victim rights fee plus a $50 state minimum cost. Each month of probation is $30 per month for oversight that you are responsible for. So I will assess that. So your total fines and costs is going to be $305. There's $50 bond that will be applied towards that, okay? Do you have any questions at this time? The rights as to probation. You have the right to request early discharge from probation once you've completed half the original term ordered by the court, so long as you do not have any violations within the 90 days prior to that request. In order to request early discharge, you would need to file a request using the court's MC 512 form. You can get that form off the court website, or you can request it from your probation officer. You would serve a copy of that completed form on probation, and then you must serve a copy also on the prosecutor's office. The prosecutor has 14 days to respond in writing with any objection to your early discharge request, okay?
Yeah.
If it's set for hearing, you have the right to hire an attorney to represent you, or of course you can represent yourself, but you do not have the right to court-appointed counsel for any hearing for early discharge from probation. Do you have any questions about that?
No.
That paperwork that you was just handed explains to you what I just went over. You'll check in with probation before you leave here. You'll be reporting monthly via Zoom, okay?
Yes.
Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Nothing from the defense, thank you, Your Honor.
You're all set with you. State of Michigan versus Philip Marin, 25-02488, appearance, please.
Good morning, Your Honor. EK Burklucks on behalf of the people of the state of Michigan. Believe that Attorney Rudoy just went to the bathroom, Your Honor.
Okay, we'll call that back in a minute. On the record in the matter of the people of the state of Michigan versus Dale Heather, 25-02987, appearance.
Jeffrey Billabay on behalf of the people, Your Honor.
Good morning, Honor. Tyler Sylvester on behalf of Mr. Healer, who is to my right.
Today was the date scheduled for a preliminary examination. This is for a crime investigation charge. How are we proceeding on this?
Your Honor, I reached out to Attorney Silvestri and I requested a stipulated adjournment in this case. The police officers who would testify in this case, they have a mandatory training which involves their certification, and I obviously did not want to stand in the way of that. It is also my understanding, I don't want to speak for defense counsel, but he had also received discovery just yesterday. And so I had reached out to him to talk about potential adjournment today, and I believe it's a stipulated request to adjourn this case, Your Honor.
Your Honor, that's correct. I was retained Wednesday evening and received a discovery yesterday, so we are agreeing to adjourn.
Your Honor, just for the record, the offer in this case is to plead guilty to a false report of a misdemeanor. I just wanted to put that on the record, Your Honor.
Thank you. Okay, Mr. Ether, you're agreeing to have your matter reset, is that correct?
Yes.
Okay. December 19th at 9:30. December 19th at 9:30. We'll get you a notice to appear. Any additional matters for the record?
No, Your Honor.
Nothing from the people, Your Honor.
Thank you, you're all set.
Thank you.
No problem. Is this, Kristen? Okay. And then we were waiting for the attorney on Maren.
Back here.
Yes, I apologize, Your Honor.
You're fine. On the record in the matter of the people of the state of Michigan versus Philip Maren, 25-0248. Appearances, please.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Your Honor, David Rudoy on behalf of Philip Marin, who's present and standing to my right. For the record, P57, 169.
Okay, Mr. Maren, that's the one that I am. Okay, how are we proceeding today?
Your Honor, we have two lay witnesses. They are here and the people are ready to proceed. However, it's my understanding that the defense wishes to ask for an adjournment.
That's correct, Your Honor. If I may.
Yes.
Your Honor, there are 4 different cases currently that Mr. Marin is charged with related to the same complaining witness. One of those cases involves criminal sexual conduct as well as 8 total counts, including similar counts. I believe that there are statements made by the complaining witness that are on video, that there would have been other versions of said statements on discovery that it's yet to be received by my office. There's also a second case in front of Your Honor that are 2 misdemeanors. I believe the people are going to be amending the information on this case to add those 2 misdemeanors to this file. I don't want to speak for brother counsel, as well as the people are going to be amending the information and increasing the charge in this case, would be my understanding, from home invasion second to home invasion first, which was just made to my awareness this morning. I have not received any discovery, and I did send out a discovery demand requesting all of the discovery for the newest case, which was just sworn to on Tuesday. And I would just note for Your Honor, the delay in that case being charged is not due to defense. I have been in contact with Ms. Abigail Tepper, Assistant Prosecuting Attorney, about arranging. Mr. Marin has been ready to turn himself in. Obviously, there was, and I did request the discovery in this matter from that case, but due to that, I don't believe I would be able to effectively cross-examine the witnesses. It wouldn't be full and fair cross-examination because I would have no idea if statements that they're making might be contradicted on prior statements that they made to the police in all of these other cases. There are quite a few videos, and I would also just note on the new misdemeanor case that is in front of Your Honor, it was confirmed to me that discovery was set and that there were 14 videos. However, that was not made aware to me. It was just a week ago, and there are 14 videos that I have not had the opportunity to review yet. I did locate them, but just this morning, so I haven't had the opportunity to review all of those videos. So for the reasons of the discovery issues related to these new cases and wanting the opportunity to review all of this new discovery that's going to be coming to me, as well as the fact that the people are amending the information to increase the charge and amending the information to put the 2 cases together, which I was not prepared for this morning. For all of those reasons, I would ask for a brief adjournment, Your Honor, so that I may be able to more effectively represent my client regarding cross-examination at the future preliminary examination.
But the request to amend is only coming after testimony, is that accurate, or?
So that is correct, Your Honor. I'm making clear for the record that we would be planning on changing the home invasion second to a home invasion first and moving the 2 misdemeanor charges that are currently before Your Honor and are set for a pre-trial on November 3rd. We would plan on combining that case into this one, as there is a stalking charge, and the stalking would be throughout the range of these incidents.
Okay, and then just so I'm clear, you also want to, that's one of the reasons why you want to adjourn, but then also because there's some discovery, you received all the discovery on this file, correct?
Well, the discovery that is directly related to this file, yes, Your Honor.
That's
but
what I'm concerned about.
Yes, but what I would say is, Your Honor, these cases are all intertwined with each other. How are they? Okay, so all 4 cases involve allegations related to the relationship of Mr. Marin and the complaining witness, Marlette Wallace. In all of the cases, there are statements made by Ms. Wallace to police. Well, I don't know about the newest case, but I must assume based on the fact that it's a criminal sexual conduct and assault by strangulation case alleged where Ms. Wallace is the complaining witness and Mr. Marin is the defendant, that she must have made statements to the police regarding their relationship. There were statements made to the police in this case regarding their relationship over the past 6 months. And so those statements may or may not be contradicted. There may or may not be exculpatory evidence in the discovery for which I have not had the chance to review. Because I can't say, and Your Honor, I don't want to mislead the court that there is exculpatory evidence contained there, but there very well could be. And I haven't had any opportunity to review all of that evidence. Also, 1 week ago, I was sent 14 videos in relation to that misdemeanor case that's in front of Your Honor, but due to a clerical error in my office, I was not made aware of that, and I have not had an opportunity to review. And so all these cases are involving different events within a 2-month period in their relationship. And throughout the discovery in this case, there are statements made about those other events. And so as far as like the witnesses' credibility and those sort of issues, having an opportunity for myself to review all of that evidence and see if, because it certainly could be exculpatory in nature, the evidence contained in these other discovery packets. And
I don't see how you can use statements from another case in this case.
May I?
Because I'm sure there'll be an objection as to relevance. If you were to question her about something she said that another time completely unrelated to this, what does that got to do with this case? He's being charged with the home invasion 2nd degree. Why do I care what the nature of their relationship was when I am determining whether or not there's probable cause about a home invasion? I don't care.
May I?
Why?
Oh, I'm sorry.
There is also, then there's, well, the other 2 are misdemeanors, correct?
There is an aggravated stalking, Your Honor, but we do not plan on proceeding on that
It says
aggravated
deny them.
stalking. Then good. I wasn't quite sure, Your Honor. I was trying to look in my file to figure out if that was. We would not be moving forward on the aggravated
Yeah,
stalking.
it was denied. So
Okay.
you have a home invasion.
Correct.
I don't care about the nature of your relationship.
May
For home
I
invasion.
respond?
And I also know that I flew back here to do this exam today.
Well, I understand that, Your Honor, but I would just note for Your Honor, it is relevant. Witness credibility is part of the determination made by
Absolutely.
Your Honor. And so if a witness's credibility is at issue and there's exculpatory evidence contained that has not been given to defense attorney regarding witness credibility.
In this file. I thought you said you got all the evidence for this file.
I did not, Your Honor. What I was making clear is I made related to the police report made here. But what has come to my attention, and I have worked to get this discovery, Your Honor, is that there were various other police reports, various other videos
On this file.
where the witness made statements.
On this file.
They are related to this
No,
file. Your
on
Honor.
this file number 25-02488.
Yes,
correct?
they are related to this
They're not-
file.
He has not received all the police reports for this file?
He's received all the police reports in regards to this file, Your Honor.
What police reports are you looking for?
I'm looking for all the police reports on that they would call on all the other files. They are all
No, it has
relevant
nothing
to
to
this
do with
case.
today.
Your Honor, this
Call your
case is the
witness.
latest in time.
I'm not withholding or holding this over when we have witnesses here. And I also, you could have notified me prior to today that you were not going to run this exam. And so you have not only wasted the witness's time, you've wasted my time. And I left my sick mother to fly here to run this exam.
Very well, Your Honor. I would just like to make a statement for the record.
You can absolutely make a statement for the record. You've made a long statement for the record. You would like to hold this over so that you can get some discovery that has nothing to do with this file because you think it has exculpatory evidence as to the credibility of this witness's statement. I don't know if she made statements that contradict what was stated here. But what I do know is what she said in another file, I wouldn't let in for you to talk about on this file anyways.
Okay, may I make a statement for the record,
You
Your
may.
Honor? Your Honor, I'm just stating for the record that will be unable to effectively cross-examine these witnesses based on the lack of discovery related to files that occurred within the same time frame as this case, and therefore I will not be able to effectively represent my client regarding his Sixth Amendment right to confrontation, and that any cross-examination testimony or any testimony taken in this case should not be admissible at a later trial, because there will not be a full and fair opportunity to cross-examine.
Did you want to respond?
Your Honor, he's reviewed the statements that were given at the time of this incident. I believe that he's effectively been given the statements that she would be testifying to today, Your Honor. And we have witnesses, we're here already.
And she's not going to be testifying about statements that was made in another file. It's not relevant to the home invasion on this file.
Your Honor, there
She's
were
here to
statements
talk
made in
about
this.
a home
case.
invasion on this file. That's what we're talking about.
I understand, Your Honor. I'm just making a record for the future potential of preliminary examination transcripts being considered non-hearsay at a trial if there was a full and fair opportunity to cross-examine. And I'm trying to make a record that this will not be a full and fair opportunity to cross-examine, because I have been denied certain discovery that I believe is relevant. If
I
the
don't
people
believe you've
want
been
to,
denied any discovery.
well, I have not received it, Your
You
Honor.
received all the discovery on this file.
Again, Your Honor, what is on this file? I would argue that this case involves a relationship. Permission to enter is one of the issues at issue in this file,
And
right? And so
potentially,
her statements and their relationship and whether or not he had permission to enter is based on the nature of their relationship at the time. She makes various statements regarding their relationship at the time on video. There are also various statements that were likely made regarding the same in all of these other cases.
on the same date and time of this incident we were talking about?
No, but Your
Because I
Honor.
can give you permission to enter my house today, and I can change it tomorrow.
Sure.
I can give you permission into my house based on our relationship this morning, and I can change it this afternoon.
I agree with Your Honor.
What does another cases have to do with this home invasion? It's not relevant. You can call your witness.
And Your Honor, I'm not trying to argue with Your Honor. I was just trying to make a record that I will not have a full and fair opportunity. To
I disagree. I
cross-examine the
believe that
witness.
you've gotten all of the discovery. You were before, we were here in August when we waived the 21 days, and there was some additional discovery that was sought. I was notified then that there was 3 additional files. Then there was a motion that was set to address his bond. We addressed that in October 20th. And there was nothing then that was stated that said, hey, I'm being withheld some discovery. I don't know if I'm going to have time to aptly prepare for this. None of those things happened. This was scheduled for today's date. We have our witness here today, and I am here today to run this exam, and you have received all the discovery on this home invasion on this date and time. What statements were made relative to any of the other 3 files are not relevant for this file.
Okay, so I just want to note for Your Honor.
You've
that if
noted
she
it. We're
makes a
not
statement
gonna
that is contradicted by
We're
prior
not gonna, I don't need you to
testimonies,
know the
then
3
it's-
different
it's-
times.
Well.
Prior
it is
testimony
what it is.
testimony in court, what testimony?
If her statements are contradicted, her credibility will become at issue.
Contradicted
You,
how?
The prosecutor and you.
Contradicted how?
So Your Honor, if somebody testifies to something for which they made a prior statement that is contradicts
in
the
this police
testimony
report,
today.
so this is the date of the incident on this. She spoke with the police officer. And you're saying if she made a statement that was contradictory to the police?
Or in prior police reports to videos. And if she made statements that contradict the statements that she made at relevant today, I would not know about them, and I would not have the opportunity to cross-examine about them. Therefore, it's not a full and fair opportunity to cross-examine, because she's made many statements that have not been tendered to defense.
I completely
So
agree, but it's still
I'm
not
ready to
relevant.
proceed, Your Honor.
You never have an opportunity to hear or to know every statement made by your potential witness prior to running an exam. That doesn't make you have an opportunity to investigate all that. You get to investigate the evidence on this file.
Sure,
And
there
so,
may be exculpatory evidence.
Yeah,
though,
and you can,
that
if
is in
this
the
case
possession
gets
of the
bound
people
over, then
and
you
not
can deal with
defense.
it at trial. Let's move on.
Thank you, Your Honor. The people will call Aaron Vidal to the stand.
Oh, may we do a housekeeping matter?
Yes.
And I apologize, Your Honor. Oh, if we're moving forward, there is a housekeeping matter at an appropriate
Yes,
time.
no, you can do that now.
Okay, Your Honor, regarding bond, we had a motion on October 20th regarding Mr. Marin's bond.
Okay, this is relative to bond or?
It's relative to bond.
Okay,
and I
let me
just
swear
wanted-
this witness in. Can you raise your right hand?
Yes,
Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes, ma'am.
You can have a seat. Okay, what are you addressing relative to bond?
On the 20th, Your Honor, of October, Your Honor ruled to amend the bond so that Mr. Marin could return to 2722 East Michigan Avenue after speaking with the complaining witness, and Your Honor made a ruling that would allow him Tuesday through Sunday to appear there because the complaining witness indicated she would not be there any other day besides Monday.
Correct.
That I'm being told by the tether part of pretrial services that they have not received that order from Your Honor's office, or it hasn't been amended from this court. And that's the information that I'm getting. So I just wanted to note that to Your Honor, that the tether company is telling him that under his orders from Your Honor, he is still not allowed to return to that building currently. And I wasn't sure if maybe I needed to file an order or.
There is an updated PA 53. It says in the other conditions, do not be within 2,000 feet of where Marlette Wallace lives, works, or goes to school. Defendant is not allowed to work at People's Kitchen on Mondays. GPS with victim notification is ordered. I think, and I'm assuming that the GPS company got this. They have not notified me of any violation, by the way.
Yeah, no, he hasn't returned because he's waiting to make sure everything is cleared. And that the tether sent me an email yesterday indicating that they still have not received notice of an amended bond from your office. That's
okay. My staff will take care of that today.
And then one final housekeeping matter, I may be playing videos if statements made by witnesses are contradicted by the statements that were made during body cam videos. And so your staff had indicated to me that I could play videos through Zoom.
Yeah, that's the best way because that cord doesn't work. So you would need to log into Zoom and then I would give you the ability to share your screen.
And then could I please have the Zoom ID, Your Honor?
876 493 1931
Did you say 31?
31, yes.
I need to get on.
Or you can, actually, let me give your witness some information. What was his name again?
Aaron Vidal.
Okay, Mr. Vidal, have you ever testified in court before? Okay, so there's a microphone that's in front of you. That microphone will not amplify your voice, so you need to speak loud and clear so that I can hear your responses.
Okay.
If there's an objection, you'll stop speaking immediately so that I can address that objection and then tell you if you can give your response or not. You must answer yes or no questions with a yes or no. Mm-hs and uh-hs we cannot understand on the record.
Yes, ma'am.
Can you state your first and last name and spell them both?
Aaron Vidal, AARON,
Just spell that again.
BEDELL.
Thank you. Proceed, counsel.
Thank you, Your Honor. And just for clarification, I would ask for a sequestration to order be put into effect. I know that there are no witnesses that we plan on calling that are in the courtroom, but I just wanted to put that on the record.
Sequestration is granted. I did note that there was a young lady that I believe is the victim that was seated next to this witness, and when he was called, she stepped out. But
Correct, Your Honor.
sequestration is ordered. And so that means for you, sir, you're not to discuss any portions of your testimony with any other witness. You may proceed.
Thank you, Your Honor. Mr. Vidal, do you know Marlette Wallace?
Yes, I do.
And how do you know her?
We've been friends for about 15 years.
Back on August 16th of 2025, are you aware where she was staying at the time?
As far as I know, she lived at the same address for a while.
Would that be an address located on 825 South Washington Avenue?
Yes, sir.
Is that in the city of Lansing,
Yes, sir.
Ingham County, state of Michigan?
Yes, sir.
Were you present on August 16th of 2025?
You got to be muted.
I apologize, Your Honor.
No problem.
I'm sorry, could you repeat the question?
Sure. Were you present on August 16th of 2025 at Miss Wallace's address?
Yes, sir.
And why were you there?
I started the day by going to hang out with her, and I ended up staying the night because she was afraid.
Understood. Did you end up staying the night that day?
Yes,
Where did you sleep?
on the couch.
Was there a point in the night where you were woken up?
Yes.
What woke you up?
Mr. Marion coming through her second floor awning door.
So coming through where?
Her second floor awning door.
Thank you.
So you say second floor, does she live in an apartment?
It's an apartment building. She was located on the second floor of the apartment building.
And when you say the second floor awning, is there some way
There's
to,
like a balcony that sticks out, and somehow Mr. Marion was able to scale the building and come up onto her balcony and through her back door. There's also a couch in her house that blocks that door. Typically, Marlette will keep that door open slightly from time to time to let her cats run on the balcony. And so it was unlocked on that evening.
Okay, let me just get an understanding, because I wasn't clear. So when you're saying awning, you're saying that that's the area that opens up from a balcony?
It's a balcony that is off of the backside of her house. Or
Okay.
apartment, excuse me.
And so you can't walk upstairs to get to that balcony?
No, you have to scale the building in order to climb up onto it.
Thank you.
thank you, Your Honor. And you said that you saw Mr. Marin open the door?
Yes. Well, I did not see him open the door. I saw him once he was flying over the couch.
Okay, understood. Had you met Mr. Marin previously?
Earlier that day was my first interaction with him.
Okay. So is that individual, Mr. Marin, is he here in the courtroom right now?
Yes, sir.
Could you please identify him by a piece of clothing that he's wearing?
He was wearing a black suit with a red tie.
Your Honor, may the record reflect that the witness has identified the defendant.
Any objections? Identification?
No objection, Your Honor.
Identification is noted.
You stated that you saw Mr. Marin jumping over the couch. Could you please explain that a little bit more?
So the door to her balcony is blocked by her sectional couch. And when he opened the door, he had to go over the couch in order to enter into the home. And I was asleep on that couch when he entered the home.
When you woke up and you saw him jumping over the couch, where did you see him going?
He beelined it straight for Marlette's room.
Was Miss Wallace in that room at the time?
Yes, she was laying in her bed. I don't know if she was asleep or not, but she was in her room in her bed.
Was there anyone else present in the apartment at that time?
So
What did Mr. Marin do when he got to the door?
to the door.
To Miss Wallace's door?
Well, he went straight into her room and turned the lights on, and I proceeded to follow in behind him after getting up off the couch.
Why did you start following him?
As soon as I got up off the couch,
Why did you start following him?
because I know that Marlette was terrified of him and that he should not have been in her home. And the whole reason that I was even there is because she was scared of him. So I immediately went into her room.
When you went into the room as well, what ended up happening?
He was begging and pleading to speak with Marlette, and she and I were both telling him that he needed to leave. And he just kept asking for time to be able to speak with her, and she kept refusing.
Did he end up leaving after those initial statements for him to leave? What did he do instead?
He went through a whole range of emotions. He went from being combative and aggressive towards me to like being nice and telling me that I'm a nice guy. I just don't understand what's going on. And I just kept reiterating, look, man, I don't really care what's going on between you and my life. Like, you need to leave here. She clearly does not want you here. Please go.
Was Mr. Marin aggressive at all to you?
Yes,
How so?
multiple times. Inside of her bedroom, he like rushed me a couple times trying to intimidate me. We kind of just pushed each other a little bit, and then that's when he changed his attitude. Started trying to tell me like, look, I think you're a nice guy. You just don't really understand like, everything that's going on. And then went back to looking at Marlette, asking if he could just have some time to speak with her.
What happened after that?
After that, we started making our, Marlette kind of made her way past and started walking towards her front door. Mr. Marin started walking that way, got close to the front door of her apartment and turned around and started getting aggressive. He rushed at me. We ended up in a tussle. He swung at me, nicked the tip of my nose. I had a messed up wrist at the time from a work injury, and I hit him with a closed fist in the side of the face. Marlette had opened her door at this point, and I more or less bull rushed him out of the property, turned around and immediately slammed the door shut and we locked it.
Now, you had stated that he ultimately swung at you, grazing your nose. Did he do that before you punched him? Did you consent to that contact? What happened after Mr. Marin was out of the apartment?
I went out onto the balcony. I told Marlette to call the police. She went and locked herself in the bathroom. I went out and started speaking with Mr. Marin on her balcony as he was trying to get into his car. He was clearly, at the time, you could smell alcohol on his breath, and I was hoping that it would buy enough time that the police would arrive before he was able to listen.
Did he leave the scene prior to police arriving?
Yes.
And police did arrive that night?
Yes, sir. Rather quickly, actually.
One moment, Your Honor.
I just have a question while you deal with that. You mentioned earlier, sir, that this was your second time seeing the defendant, Mr. Marin,
Yes, sir.
and then you saw him earlier that day?
Yes.
Why is that?
Marlette and I had gone to, I believe it's called Lansing Lake.
Lansing Lake?
Lake Lansing.
Lake Lansing?
Yeah, we had gone to Lake Lansing and we were out there at the beach area and Mr. Marin just showed up out of the blue there. And she asked him to leave. I had actually gone to the bathroom and when I came back, he was speaking to Marlette. I had no idea who he was. She clearly did not want him there. I asked him to please leave. He proceeded to try and make me feel weird. It was a very odd conversation. He was like, yeah, me and Marlette were having sex last night. And she told me that you look like Shrek and just, he was trying to clearly get under my skin. And I had no idea who this guy was.
Okay, but she lives on South Washington, correct? Not near Lake Lansing?
Correct.
Okay. You can continue.
Thank you, Your Honor. Nothing additional.
Cross-examination.
Your Honor, I just wanted to make sure I have some video queued up.
Absolutely, you just, let me see.
I just need to get my, the Dropbox videos all right. I was trying not to do anything that would distract from the direct examination.
Got it.
while
Yeah,
it's
you
happening.
should be able to get everything running, and I'm going to make you a co-host so that you can share your screen without problem.
Thank you, Your Honor. I'm a little slow. I think it may be easier. I apologize. I'm gonna just sign in from a different device. I'm having some trouble with this device. I apologize. Can I get that Zoom ID one more time?
Yes, it's 876-493-1931. Lost the record for just a second.
It looks like I'm just in the break room. Go.
You just have to stay muted, yep, stay muted. And I'll be right back.
You got it.
So, like,
It's not. You know that's a myth, right? But it's like some captures. And it's fun. Using all hollows. Yep. So. So that you say you remember. Huh? Yeah. And so we used to like. Action. No, I'm just, I was just sanitizing. In case they were to see it.
Wait, what do you say? So next week.
It's holy, it's actually. Yeah. Which is fine. It probably is. But- So, yeah, that like.
Good time.
I don't know. I guess 7:30, it's not true. Also, people.
No, we're off the record. Might get a proper pronunciation of your last name. Sorry.
Vidal.
Yeah.
Vidal. Vidal.
You know, so like I'm just any experience, I'm good or bad.
Yeah, we get a lot of trick or treaters.
Huh?
We get a lot of trick or treaters.
At your house. I bet you have it deck. Oh, you're so happy.
He also loves you.
Yeah, yeah. It's true. But he has, he
I'm
has-
lucky. So lucky.
he is a lucky, he's a lucky guy, for sure. The thing is, so like, how much do you put out? And is it always in your back?
I
Oh,
I was
you are-
wondering, like, can I actually walk that?
That's why it's so much.
Put it on the-
Kids and kick the ball and take ones, some like in use. Chilly, but. No rain, no snow.
I'm excited. That's true. You can.
Yeah.
I just love the fact. So, you know.
Supposed to have went already.
Oh, Lord. Oh, that's rough. Bam.
Wow, you're always welcome.
I know.
So now that it's found over there, I mean, supposed to go.
It'll be put on to, so right here, I'll put on the information and we'll get sent up on the new information. Well, I'm gonna be making a record of it. I'm gonna be making a record of it. So it's not like we're just adding it just because.
No, I know, I'm only, not trying to say you're doing things wrong. I'm just questioning the procedure. That's all. Like, I actually want them to be added to this file, to be clear.
I would assume so.
I just was more questioning like what, that once it's already in circuit for your ability to add misdemeanors on. Exactly today, it's gonna get found. And I don't know if you can just add misdemeanors on that circuit board.
So that's why we're adding it now. We're doing it, adding it on the record now. When it gets, the information gets submitted to the court, it's gonna have to be posted.
You know, like, I don't mind, to
Yeah,
be
yeah, yeah.
clear. I'm more just questioning the process.
At least the jack.
And that's it. I guess in the circuit court, you can amend the complaint for this.
Yeah.
But like.
The only time I'm actually gonna have it.
Surprising.
I'll probably want to.
I feel like most people don't want to have some sort of.
Okay.
That's all. A lot.
Yeah, it's, okay. I wanted to do that. for a
I don't know
while.
the judges.
I realized.
I'm a judge candidate right now.
Yeah, I was just wondering if you have it in your system.
I don't know who the judges is gonna be right now. I don't. Unfortunately.
As long as that, like, you know, seconds.
Abigail,
You know, you're sure it's like that.
district court, new district court prosecutor for the 55th Judge Allen.
Yes, that is,
Zelly?
yeah, Gabriella's.
Gabra.
That's-
She made me-
Maybe. Unfortunately, I do not.
I mean, I got
So,
It's not you one lady with a.
Is this our case?
No,
Okay, I was gonna say, you're a lawyer and you don't have.
it's not your team, but I'm wondering how you can send. I wish the city would. No. A lot of work. All day. So. I don't know, I haven't talked to him. Being an owner, I don't know business like that. Oh, and now that she did. She called me. It's a lot of work. She did what she knew, statute. To get reports of law enforcement general. She reported law enforcement. Well, we started. So later. I haven't heard. And within a year after that. You know, so like the numbers were, and I knew it would do that. But I thought that was 4 years, and in 1 year, it dropped by more than 56%. I think 54%.
You should have said something. I thought this was.
It's like. It dropped by about 85%. Turned it into like a high. We're being really good at
Bring up snack.
Hey.
Especially today.
Yes, Kristen, listen.
To me, it's pretty bad.
So I-
She said it.
That's my spot now. Where
Hey, Andy.
I
didn't think so.
Yeah.
You would know what you would say.
I eat, I just eat a little better.
Mine is just different, man.
Than this one right here.
Garbage is supposed to be here. All right.
Okay, you can be seated. Are we ready, council?
We are ready.
Okay, are you to proceed with cross exam?
I'm having a problem where I can't make this stop making noise and reverberating. I'm gonna sign out, and if I choose to.
You said reverberating? Like it's making a background noise, what you
It's
mean?
making a background noise. It's repeating everything in my iPad, and for some reason, I'm a bad technology person.
Are
I
we
keep trying
hearing
to
it or
turn
just
off.
you hear it?
Just
I
the
think council
iPad is,
table.
Your Honor.
iPad.
Are you able to turn the volume down?
I don't know why, but every time I turn it down, it turns itself back up. It's like a weird feature of Zoom. I'm gonna go ahead and turn it off. And if I need to actually play the video,
All right,
I'll
listen, I
sign
don't know what's
back in
going on
if that's
with
okay
Zoom.
with Your Honor.
Zoom on my laptop, if I try to turn my camera on right now, it shuts my whole computer down.
I wish I could give you some explanation of why.
That's all right. Okay, you can proceed.
And it's Mr. Bedell.
Yes, sir.
Okay, just, I know I asked you, but I like to get people's names correct, so. All right, Mr. Bedell, I just first like to ask you a little bit about what your preparation to testify today was. Did you take any measures or review any paperwork or any statements you made in police reports to prepare to testify today?
No.
Okay. Did you review any videos that were given to you by police, for example, of like your earlier
I've been provided
statements?
nothing.
I'm sorry?
I've been provided nothing.
Okay. Did you meet with the prosecutor prior to today? Have you met with representatives from the Ingham County Prosecutor's Office regarding your testimony?
The only person that I've spoken to in regards to this case was a victim rights advocate.
Victim rights advocate. So prior to today, you have not spoken with anybody from the Ingham County Prosecutor's Office?
Not that I can recall now.
Okay. And today, did you speak with the assistant prosecutor regarding your testimony today?
Yes, momentarily on the whole. So,
Okay. Did he discuss with you your potential testimony?
he told me that I would be testifying today.
That's it.
I would need to speak today.
Okay, I guess I was just, I'm just trying to cover my bases here. Did you guys have any discussion regarding what you would testify to?
No.
Okay. Did you have any discussion regarding potential cross-examination?
No.
Okay, so, okay, so I want to talk to you about, you said you're a longtime friend of Marlette Wallace?
Yes, sir.
Okay, how long have you guys been friends?
Just short of 15 years.
Okay, and do you live at, I'm just guessing based on your lack of knowing Lake Lansing. Are you from somewhere else?
I live in Ann Arbor.
In Ann Arbor,
Yeah.
okay. And how often do you guys see each other and talk?
Depends on the year. Sometimes we're seeing each other like multiple times a month, other times, we're 6-10 months without seeing each other.
Okay.
Depends on what's going on in life.
How often were you guys interacting, whether talking or seeing each other in person around the time of this incident?
So I actually hadn't spoken to Marlette in 7 or 8 months before the day of the incident.
You didn't speak at all?
Yeah, well, I mean, social media speaking, things like that, but I've been very busy with work and she's been doing things.
Okay,
And then afterwards, I found out that she was scared to speak to me because of Mr. Mann.
okay. So you did continue to follow her social media? Is that what you're saying? But besides that, you didn't speak for 6 or 7 months?
Correct.
Okay. And were you aware that Marlette was in a dating relationship with Mr. Barron?
No.
So prior to August 16th, when you saw him at Lake Lansing, did you have any awareness that Marlette had prior been in a relationship with Mr. Marin?
Part of our friendship doesn't really involve who she's dating. It's not something that is important that I call and check up on who she's dating.
Okay, and I guess I'm asking a little bit of a different question. I was just asking, were you aware?
No, I did not know of Mr. Marin until I met him at Lake Lansing.
Okay, were you aware that she was in a relationship with anybody?
No.
So on August 16th is when you and Marlette were at the public beach at Lake Lansing. Is that correct?
Correct.
Were you aware that that Marlette had a FaceTime call with Mr. Marin while at the beach?
Your Honor, I'm going to object to relevance.
Did you want to respond to the objection?
Yes, Your Honor. I believe it builds towards relevance. Your Honor Your Honor actually asked him some questions regarding the incident at the beach. And I am just asking some cross-examination questions relevant to that particular incident.
Your question was whether or not he was aware if there was a phone call prior to.
Yes, and it's related to his.
Objections.
Okay, thank you. And I'm sorry I missed your answer, Mr. Bedell. Were you aware that Marlette had FaceTimed Mr. Marin from the Lake Lansing public beach? Okay, and so then there was an interaction at the public beach, right? There was no physical assault that took place during that interaction, correct?
No.
No assault from Mr. Marin upon you?
No.
No assault from Mr. Marin upon Marley?
No.
And I apologize, what do you normally call Miss Wallace? Is it Marley, Marlette?
Marley, Marlette.
Oh, all three, okay. I just didn't want to confuse you by using
No.
the incorrect name. Okay, so there's a verbal disagreement that happens with Mr. Marin and Marley, correct?
Yes.
And this isn't a public place.
That's what.
Was in a public place, true? He had a right to be there?
Yeah.
Okay, but you told him he should leave?
Yes.
Okay. Did you threaten him to
That
get
he
him to
was
leave?
making Marlette uncomfortable and that he should just go.
Okay. Did you threaten him in any way and during that interaction?
No, I didn't even know who he was.
Okay, did you shove him during that interaction?
No.
Okay. So when you came to town, your plan was to go to Lake Lansing for the day with Marlette?
No, I came to town and we made a plan to just go out to Lansing once I was here.
Okay. And
I came to town to celebrate my birthday, which is the 19th of August.
so you're coming to town to sort of celebrate your birthday with Marlette? Okay. And you end up going back to her apartment and sleeping. And so based on your statement that you were celebrating, did you engage in, I guess first, let me ask, did you guys go and drink any alcohol either at the beach or at your time after the beach before going to sleep?
No, both Marlette and I were sober.
Okay. And just to be clear, are you saying that you were completely sober, that there were no other substances used, for example, marijuana?
Correct.
All right, no marijuana or any substance of any kind?
Correct.
Okay. Besides going to the beach, did you do anything else to celebrate?
Yes, she took me to some Asian massage place at the mall. She was returning stuff to Dick's Sporting Goods, and then there's like a open place where there's like 20 beds and you can get a massage in there, and she and I both got one.
Okay. And then you went back to her apartment?
Correct.
So there were no bars involved or anything like that?
No.
Okay. All right, so then you are sleeping on her couch.
Correct.
That is next to a door wall?
Her front door is the front part of her sectional, and then her balcony door is the L part of her sectional. It's a very tiny apartment.
Okay, I'm just trying to picture this. So there's an L-shaped sectional that her front door kind of is next to the one part of the L.
Correct.
And then her balcony door, and is that a sliding glass door?
No, it's opens outwards.
It opens outwards.
Correct.
Okay. And so you wake up to that door being opened?
I woke up to him coming over the couch.
Okay. And you used this term during your direct examination, that flew over the couch.
Yeah.
What exactly did you mean by that?
I mean, like, he came with intent over the couch.
He came with intent.
Like, the couch is relatively high, and he like hurtled over the couch into the house. That's what awoke him.
He hurtled? Like were his hands, or did he just jump over? Did he
Like I
climb
said,
over?
I don't know. I just saw him literally in the air going over the couch, and that's when I woke up, saw him, was like, what the hell is going on?
Okay. Did you say anything to him?
There wasn't really an opportunity. By the time I noticed what was happening, he was already beelining it down the hallway to my room. He said, it's a very tiny apartment.
I have a quick question. Was it the same couch that you're sleeping on?
Yes.
Okay.
Yes. I was on the long part, and the short part is what covers.
Oh, because it's a sectional.
Yes.
And just to be clear, where he came over the couch, was it over your body?
No, I was on the long part of the couch and the sectional L part, the short part is what's in front of the
Okay, so he came over the short part, that's not over where you were sleeping, okay? And did he see you?
You have to ask him.
Okay, you didn't get any indication that he saw you.
All that I saw was him flying over the couch, heading straight to it.
Okay, so he walked towards her room, okay, and entered it, true? And he was asking, to speak with Marlette.
Marlette told him that he was not allowed to be there to get out. And he said, please just give me time. Like, I just need a couple minutes to talk to you. Like, please let me just talk to you.
Okay, so he wasn't attempting to assault Marlette, like that you saw.
No, he did not attempt to assault Marlette.
Okay, and he didn't attempt to break any property, did he?
No, he was at the time pleading to speak with Marlette.
Okay, he was pleading to speak with Marlette.
Right.
And I kind of want to skip forward in time here. At the end of this incident, you spoke with the police, right? You spoke with multiple police officers, right? And when you were speaking with police, did you understand that it was important to be truthful with them?
Yeah. Speaking with police.
Yeah, okay. And you understood that when you're speaking to the police about an alleged crime, that it's very important to be truthful, right? And so when you spoke to the police at the time of this incident, you understood the importance of being truthful, right?
Yes, my grandfather was a highly decorated state trooper, former state trooper, and I understand the importance, yes.
Okay, and would you say that your memory of events generally gets better with time or worse? Like you remember something, okay, so you,
I'm human.
okay. And so would you agree with me that your memory of what happened that night was likely better when you were talking to police the night of the event?
I would say that's accurate.
Okay. And you believe that your statements that you made to the police, because you understand the importance of telling the truth to police, and because your memory would have been better, that those statements would probably be the most accurate statements regarding what happened.
Yes.
Okay. All right. So getting back to.
Can I stop you real quickly? I'm gonna have him escort it out. Okay, you can continue.
Thank you, Your Honor. Okay, so getting back to the incident, okay, so Mr. Marin is inside of Marlette's bedroom. It's a single bedroom apartment?
Yes.
Okay, and so he's inside of Marlette's bedroom and he's asking to speak to her. You go in there, right? And isn't it true that you tell him to leave?
Yes.
And you shoved him?
I'm not sure.
Okay. Do you remember telling the
I did not
police?
shove him until he charged at me.
Okay, he charged at you. Do you remember that you told the police that you shoved him inside of her bedroom?
Once he charged me.
Okay, so when you say he charged you, you would agree with me that he never touched you.
I was intimidated. I was afraid he was in the swing. I could smell the alcohol on his breath. And I was concerned that he was going to do something to me.
This is a small apartment, isn't it?
Yes.
Okay, so when you say charged you,
He moved about 3 feet in my direction angrily.
he moved 3 feet in your direction. He didn't have any fists up, right?
His body was up like this.
So he didn't have any fists up, did he?
Was he ready to spawn? No.
Okay.
I need you to keep your voice up, sir.
I'm sorry.
I didn't hear your last statement.
I said, if you mean, was he ready to spar? No.
Okay.
Okay. And he didn't make any movement towards, like with his arms towards hitting you, did he?
He raised his arms like this. towards
He raised his arms backwards like this,
up in an upwards motion.
like this?
Yes.
I guess I'm confused.
It was an intimidation. I don't know how to define that. I'm not
Okay.
an expert
It
in
wasn't,
movements, but
it wasn't a move that made you believe he was going to
it was a
take a
move
swing
that
on you.
made me feel like he was going to potentially do something to me.
potentially.
Yes.
Okay. At no point did he put his hands on you, did he?
In that moment, yes, once I pushed him backwards, he came back to me and then we kind of stopped. And that's when he had a complete attitude change towards me and was like, look, I think you're probably a really good guy, but you just don't understand what's going on.
Okay, so I just want to get this straight. So before you pushed him, he had not made contact with you in any way, true?
He had not made direct contact with me.
Okay, and you shoved him, right? And you knocked him backwards,
Yes.
true? And then after you shoved him and knocked him backwards, his attitude changed with you, right? And he told you he believes you're a nice guy and that you just don't understand the context of what's going on in this situation, right? And so he never took a swing on you at that point, right? Okay. And so that was the first shove, right? And it's true that you shoved him a second time in the living room. Isn't that true?
After he saw me.
Okay. Do you remember that you actually told the officers that there were 3 separate times that you shoved Mr. Marin?
The third shove was me shoving him on the house.
Okay. So, and that you actually told the officers, and you just tell me if I'm correct or not, that you told the officers that you shoved Mr. Marin when he was at the door, in the doorway.
It was not in the door, it was near the door.
Okay, he was near the door,
Right.
you shoved him, and then he took a swing on you. Isn't that true?
After he had charged towards me from the front door. We walked towards the front door and then he got really aggressive, charged at me again, and that's when I shoved him back. He swung at me, hit me in the nose. And then I hit him with my closed fist on the side of the face, and then I shoved him out of the apartment. And then turned around, went back in and locked the door.
Okay, so I just want to make sure I get all of this very clear, okay? So I'm gonna kind of take it one step at a time, if that's okay. So you've already shoved Mr. Marin once, right? Now Mr. Marin is in the doorway because he was proceeding to leave, correct?
He was not proceeding to leave.
Well, he walked all the
He
way to the
followed
doorway,
my right
correct?
out into the living room, which is where the door is. So anything that took place in the living room, I guess you could consider he was attempting to leave, but no, his actions, body language, everything were not that he had any intention to leave.
Okay, and he was begging, and throughout this whole time, he's begging, can I just have 2 minutes, 5 minutes,
Yes.
that sort of thing, right?
Correct.
Right. And so he's within 3 feet of the doorway. Would you agree with that?
Yeah, anywhere in her living room is within 4 feet. of the door.
Okay. And again, he didn't actually make any contact with you, correct?
Correct.
And you shove him a second time. Is that true?
The second time is when he rushed me.
Okay. He rushed you, but he didn't touch you, did he?
By the time that he was in my face, I don't know how to explain what happened other than he came at me and I wanted him to get away from me.
Okay. So you pushed him a second time, right? And it was only after that second push that Mr. Marin took a swing and grazed your nose, I believe, is what you described it as. That grazing of your nose, it did not hurt you, did it? Okay. Did it actually touch your nose or did it just come near your nose? Because it's a little unclear from what you told the
Nicked the tip of
police.
my nose.
Nicked the tip of your nose,
Yes.
but it didn't cause you any pain or anything like that?
No.
Okay. And then at that point, you punched Mr. Marin with a closed fist on
It's
the,
more of a smack, but yes.
okay, you said you had a closed fist.
Yeah, my wrist was messed up from a work injury, so I couldn't really punch, so like that.
Guess what, if you, a smack,
It was a
maybe,
closed fist.
I just want to
smack.
understand what you mean.
A closed fist smack.
Okay, so like it was you swung your arm,
Correct.
but you hit him with a closed fist,
Yes.
On the side of his
Inside
face.
Yes.
okay? And Mr. Marin never took another swing on you, did he?
No, we didn't have a chance. I flushed him out of the apartment.
Okay, but he never tried to take another swing on you, did he?
No.
Okay, and so you hit him with your fist to the side of his face, right? And then you shoved him now the third time, right? And you like, it was more like, I think you described it as like almost a bum rush
Yes.
out of the apartment. Okay, And at no point during that did he attempt to attack you,
He turned around and tried to come back through the door, but we had blocked it.
but he didn't take another swing on you, did he? He didn't try to assault you in any way, did he?
He had already tried to assault me and. he
I'm
was-
saying prior, and I just want to be very clear, after you bum rushed him.
No,
Did he try to assault you in any way? Okay. And then once outside of the apartment, you went out to the balcony,
correct.
right? And saw Mr. Marin outside.
Correct.
Did Mr. Marin attempt to assault you at that time?
We couldn't use, well, maybe this could, we had already scheduled with the one, but
So he didn't attempt to get up there a second time? And he didn't attempt to throw anything at you? Or did he tell you he was going to assault you?
No.
Did he make any threats towards you? All right, and just to be clear, throughout this entire incident, Mr. Marin never made any assaultive threats towards you, did he?
just gestures.
So, okay, but no words that were assaultive threats, wouldn't you agree? I have no further questions, Your Honor.
Redirect.
Nothing additional, Your Honor. Thank you.
Thank you. So you may be removed from the stand. Thank you. You can call your next witness.
Yes, Your Honor. The people call Marlette Wallace to the stand.
Have you raised your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Yes, ma'am. You can have a seat. There's a microphone that is in front of you. The purpose of that microphone is so that the lady behind you can hear everything through the recording system, because a record must be made during the open court proceeding. It does not amplify your voice, so I need you to speak loud and clear. I need all of your responses to be verbals. So if there's a yes or no question, you have to say yes or no. You can't do a head nod or shake. You can't say Otherwise, we'll have to ask you if that's a yes or no, okay? Thank you. If there's a objection from either of the attorneys, you will stop speaking immediately. I need to make a ruling on that objection, and then I'll tell you if you're allowed, according to the court rules, to give that response or not. First, state your first and last name and spell both.
It's Marlette Wallace, Marlette Wallace.
You can proceed.
Thank you. Marlette, how are you doing today? Do you know a Philip Marin?
I do.
How do you know him? For how long?
5.5 months.
Did your relationship with him end?
Okay.
When did it end?
Around the end of July.
I need you to speak up, please.
The end of July.
Thank you. I want to direct your attention to the date of August 16th of 2025. Did you end up spending the day with a friend of yours?
That's Aaron Vidal.
And what was the purpose of that visit with Mr. Vidal?
Just hanging out with friends. We went to Lake Lansing.
Did something ultimately end up happening at Lake Lansing?
I was hanging out there and I had a therapy appointment. I walked around the water away from Aaron for my therapy appointment. When I came back, Philip was talking to Aaron.
Did Mr. Marin end up showing up at Lake Lansing?
Yes.
Maybe you could describe to the court exactly what happened during that.
I was not expecting him to be there.
So you didn't invite him?
I did not.
So did he make contact with you at that point?
He did talk to me.
Were you concerned after that incident?
I just wasn't expecting him to show up.
Later that day, did you go back to your apartment?
I did.
Where's your apartment located?
825 South Washington Avenue.
Is that in the city of Lansing,
It is.
Ingham County, state of Michigan?
That's correct.
And what floor is your apartment on?
The second floor.
Did Mr. Bedell end up coming to the apartment with you?
Yeah, we had dinner and we're watching some Netflix shows.
Mr. Bedell spend the night?
He did sleep over on the couch.
Was that couch in the living room?
It was.
And where did you sleep that night?
I was in my bed.
Did you end up hearing any, did you end up waking up at any point in the middle of the night?
I was laying in bed trying to fall asleep and Mr. Mann came in my bedroom.
When you say Mr. Marin, is Mr. Marin here in the courtroom right now?
Yes.
Could you please identify him by a piece of clothing that he's wearing?
Red tie and black suit.
Thank you. Your Honor, may the record reflect that the witness has identified the defendant.
Any objection?
No objection, Your Honor.
So noted.
Thank you. You said that he came into your bedroom. Did you give him permission to be in your apartment on that day?
No, I did not.
Did you give Mr. Bedell permission to be in your apartment that
Yes, I
day?
did.
What happened when Mr. Marin entered your bedroom?
He turned the light on. I asked him what he was doing there. He said he just wanted to talk to me.
Did you want him in your apartment at that time?
At that time, I did not.
At any point in time, did Mr. Bedell get involved at that point?
Not for a couple minutes, maybe 2.
What happened when Mr. Bedell was in your bedroom? Did he go into your
Yeah,
bedroom
he
as well?
came into the bedroom. He said, "I'm sorry, Marley, I tried to stop him before he came in." He said that he needed to leave to look.
Was Mr. Marin aggressive with Mr. Bedell at all?
Not in my bedroom.
At one point, did the two of them leave the bedroom?
Yeah, I had asked him to leave. At least a handful of times and just decided to try to walk out with him to the door.
Okay. What happened when that happened?
There was a confrontation between Mr. Marin and Mr. Bell.
When you say confrontation, can you give a little bit more detail as to what that means?
Yeah, so he kept asking to just be able to talk to me. Like just give me, 5 minutes to talk to you, and 2 minutes. I kept saying no. And then Erin said, "I've known Marley for 15 years. She said she doesn't want to talk to you. She's asked you to leave. You need to leave, or I'm gonna call the police." He said, "I know Marley."
Did you see Mr. Marin attempts to get physical with Mr. Bedell at that point?
He had gotten really close face to face with him.
Okay. Did you see any kind of swing that Mr. Marin did? Mr. Marin attempt to make contact with Mr. Bedell?
This
If
is
you
hard
saw.
for me. I don't really remember this. I know that Aaron had swung in defense, but I do not remember. Really overwhelmed.
Was there a lot going on at the time?
Yeah, it was.
What was kind of going through your head?
I didn't want them to fight each other.
Did Mr. Marin end up leaving your apartment?
Yeah, after they were, face to face, like that. He did, Mr. Bedell did make contact with his hand to his face. Wasn't like a complete punch. I know he had just hurt his wrist. So it's kind of like a more close hand. Describe it like that, but I don't feel like it was like a straight punch to the face. And then,
Do you know what
because of
that,
it, he had an injured wrist.
do you know what that smack was in response to, if you can remember?
I just remember him, him just getting right up in his face. We did talk. I just think maybe because I was so overwhelmed, it's really hard for me to know.
I understand.
I do know that he felt like he had to defend himself, and he did push him out of the door, into the doorway and shut the door after.
When you say he pushed him,
Aaron pushed Philip
Aaron pushed Philip outside.
outside of the door, yeah.
So Mr. Marin did not leave willingly.
That's correct.
What happened after he left your apartment?
I know that there was some back and forth on the balcony. Where Aaron told him to never come back.
Did you call the police?
Aaron did.
Did the police arrive that day?
He did.
Did the police arrive when Mr. Marin was still present?
That's
Mr. Marin was there when the police
Oh,
arrived?
excuse me, Mr. Bedell. was there.
Mr. Bedell was present.
Yeah, Mr. Marion had left.
Okay. I just want to make sure this apartment that you were staying at, this was your apartment,
This is where I live currently, and at the time.
was Mr. Marin's name at all on the lease or anything like that?
No.
One moment, Your Honor. Nothing additional, Your Honor. Thank you. Oh, no, please, yes, nothing additional. Thank you.
Person him.
Okay, yes. do you prefer to go by Marley, Miss Wallace?
I don't know.
Okay. All right, so I'm Attorney Dave Rudo. I'm gonna ask you a few questions. I just ask if there's any questions I ask that are unclear or you don't know how to answer them or anything like that, please let me know and I'll restate it, rephrase, okay? So I want to talk first about, did you do anything to prepare to testify today? Did you review any police reports or?
No,
Did you speak with anybody from the Ingham County Prosecutor's Office regarding your testimony prior to
I
today?
didn't.
Have you spoken with any officers regarding your testimony today?
No.
In between the time of this incident and today, have you had conversations with Mr. Bedell about what happened that night?
I have not.
So since August 17th, you have had no conversation with Mr. Bedell regarding the events that took place that night?
Only if you would be in court today.
But nothing, and I guess, so you just to clarify, you discussed that he was showing up to court,
Yeah.
but you
about a
didn't,
month ago.
but you never discussed what happened.
Like ever?
Like since August 17th till today. So it's been about 3 months, right? A little over 3 months.
We haven't really been talking.
I guess 2.5 months. I'm bad at math. So in the last 2.5 months, have you had any conversation at all with Mr. Bedell about the events that took place that night?
If he's gonna come to court or not.
Okay, and I
But
guess
we had a little falling out, so we haven't been talking.
okay. And I just want to clarify, and I'm not trying to give you a hard time here. I know you're trying to do your best to answer. I guess I'm just at all after the fact, like
Like
before
the
you had your
next day,
falling
we
out.
talked about it.
Okay,
Yeah.
okay, so you did kind of discuss what you remember and what he remembers, right?
The next day we discussed him breaking in.
I guess, but I'm just saying, you guys had discussions about what happened, right? And what, for example, Mr. Bedell remembers, and you told him what you remember. Is that fair to say?
Sure.
All right, so I just want to get a little bit of a background of you and Mr. Marin's relationship. How long, like leading up to August 17th? Well, I'll ask a better question. How long did you guys engage in a dating relationship?
About 5.5 months.
Okay, so approximately when would your relationship have started? Where you guys were actually in a relationship?
So we met, maybe, right a couple weeks after Valentine's Day.
Okay, so in February.
Maybe that end of February, we didn't. That would be maybe just 5 months then, because it was like right after St. Patrick's Day. I was drinking, not on at the bar.
On St. Patrick's Day?
No, not on St. Patrick's Day, right after.
Oh, right after, I'm sorry.
Maybe the following.
Okay, so in March, I'm not Irish, so I don't know the exact date, but somewhere in March, towards the end of March, you guys started dating. Middle of
Well,
March,
officially, maybe, but we met like maybe, yeah,
mid-March.
maybe the third week.
Okay.
I think mid-March is St. Patrick's Day.
Okay, and you guys had a relationship where the relationship developed where you guys would commonly spend the night together, correct?
That's correct.
And
Mostly at the house, not mine.
Mostly at his house, but sometimes at yours, true?
Rarely at my house.
Okay. Rarely at your house, commonly at his.
That's correct.
Fair enough. And throughout your relationship, is it safe to say that there were, it would happen often that you guys would kind of be on again, off again? Like break up,
Yes. We broke up a lot.
you broke up a lot. That's, I guess, what I was
There
trying
was
to
a
get.
lot of broken promises and breakups. Getting back together.
Okay, a lot of getting back together, right? And would you agree with me that it would happen, I don't know if I would say common, but it happened that you guys would go through a period of time where you weren't talking, and then you would come back to his apartment, or I'm sorry, to his house?
No, we never went through long periods of time where we weren't talking. We would still text each other almost every day.
Throughout the whole time?
Until about the end of July. That's when I stopped talking to him for a bit.
I'm gonna ask a better question. Was it common that you guys would go from a breakup or being kind of like on a break? I don't know exactly, you know, the on again, off again, kind of from the off again, where you guys would be off and you would come and you would show up at his house.
I would say we were always texting each other. I never had where we went more than a couple hours without texting. So there was always a conversation going on. There was never in those 5 months where we weren't talking for like days or weeks. So
Okay.
I would say we had daily conversations.
You had daily conversations. And I guess what I'm trying to kind of get away from asking you about, and I know you're trying to answer my question, so I'm just trying to get to a little bit of a different question. Was it common that you guys would be on like where you're saying you're going to be broken up with each other, or you know, you guys are putting that out there, and then you would show up at Mr. Marin's home?
I would say that we wouldn't have an official, we're not dating anymore, but there was a lot of lies that I was fed up with. And we would be talking and sometimes I would come over. I did have a key to his house.
Okay, so you had a key to his house and you would, and am I correct that you would just go into Mr. Marin's home even if he wasn't home?
Objection, Your Honor, relevance of this.
Did you want to respond to this?
Your Honor, I'm kind of building towards, you know, why it would be relevant was having to do with permissions to enter. And I believe that the nature of their relationship and permissions to enter are very involved here.
Okay, and so your question was whether or not she had access to this?
Yes, correct.
And Your Honor, I'm not sure the relevance of that when we're talking about an incident where he came into her apartment allegedly through a balcony instead of through a key or door or anything of that nature.
And may I respond?
Yes.
Your Honor, if somebody has permission to enter my home, you know, commonly relationships are oftentimes reciprocal. And so I believe it is circumstantial evidence. If somebody is allowed to just enter my home without me being home and we're in a relationship, that I might have a similar permission going the other way. And for example, even though I might have a key to somebody's apartment or to my own home, and I forgot that key, then I might jump up on the balcony to get in. And that doesn't necessarily mean that I don't have permission or don't have a key. That just means that I didn't have the key at that time. And so I'm trying to just ask questions regarding circumstantial evidence related to one of the elements of the felony here in this case.
I can understand the investigation into the nature of permissions at that time. She's already testified that she didn't give permission that day to be in her house, but I'll allow you to ask your line of questioning.
Thank you very much, Your Honor. So Marley, getting back before we had the break here, during the course of your relationship, even when you guys were in a fight, you felt that you were able to enter Mr. Marin's home. Isn't that true?
It depends. Sometimes he would ask me to come over, so I guess it would be circumstantial.
Okay.
But he did give me a key. And I guess it just depended if we already talked about it. Different occasions I would not, if we hadn't talked about it,
And isn't it true that at times,
but he never had a key to my home.
okay, so your testimony is that you never gave Mr. Marin a key to your home at any time?
That's correct.
Okay. Now, just getting back to with his home, isn't it true that there have been multiple times where you would walk into Mr. Marin's home, even when he wasn't home, during a time when you guys were in a fight?
I don't know if that's true.
Okay, and I'm not trying to give you a hard time here, Marlette. I'm just, you said you don't know if it's
We
true.
fought so often, all the time, constantly, over things that were going on in our relationship. So to say that is very confusing.
I'm
Because
sorry.
the entire relationship, we were fighting over what was going on.
Okay, so you're fighting a lot, right? And
Yeah,
what I was kind of gonna follow up with is like, when you say, I don't know if that's true, are you saying like you don't remember, like that might
well,
have
you're
happened and you
asking
don't
me if I
remember?
ever came into his house while we were fighting. In the entire relationship, there was fighting going on. I would stay there, I would clean his home, I would do his laundry, I'd put his laundry away. So, sometimes I'd be staying there for an entire week. So to say, were you coming in while you're fighting, we were fighting the entire relationship.
Okay, I understand what you mean now.
Okay.
And I think that adds some clarification to what I was
Right,
trying to ask
because
about.
I would still be cleaning or staying there while he was at work.
And would you, I guess, let me,
So to
would there
say
also
when
be
we're
times where you
fighting-
guys would go multiple days without seeing each other? And then you would still just come right into his home?
We really didn't go many days without seeing each other.
Okay. Were there times where you went a couple days without seeing each other?
Very, very rarely. I don't, it's hard to recall. Honestly, we were together a lot.
Okay, fair enough. But throughout the relationship, there was never a time where you didn't feel welcome to just walk into his house, whether he was home or not. Isn't that true?
I guess it just, a lot of times he would, beg me to forgive him, and come over, so.
All right, and I'm asking a little bit of a more specific question. I know you're doing your best to answer my questions here. But like, there was never a time during this relationship where, whether you guys were fighting or not, where you didn't feel that you had the ability to just walk in his home. You had a key and you had the ability to enter when you wanted to. True?
Possibly, I mean, sometimes I still knocked if I felt like we didn't talk about it first, so.
So sometimes you knocked, but a lot of times you didn't. True?
That's true, yeah.
Okay. Okay, so you said that you and Philip had been broken up since around the beginning of, or the end of July, is that correct?
Yeah.
Okay, and was that like fully broken up? You're not talking anymore?
We had spoke maybe a handful of times in 3 weeks, but I had blocked him on social media. I had blocked him and unblocked him on the phone.
And just to kind of nail down the date, when exactly did the full-on breakup start?
I couldn't say a date. I just know it was towards the end of July.
Okay, towards the end of July was when the full-on breakup started. So not in August, right?
I would say the beginning of August, end of July
Okay.
is around the same
You
time.
don't remember the exact timing?
I could not tell you the exact.
Okay,
date,
fair enough.
no.
Going towards August 16th, was the day that Mr. Bedell came into town and you guys went to Lake Lansing, right, correct?
That's correct.
Okay. And on that day, isn't it true that you FaceTimed Mr. Marin multiple times?
We talked while he was at work.
And isn't it true that you actually initiated that by calling him using FaceTime?
That is true.
And FaceTime's, just for the record, you had the video feature.
We were video chatting while he
Video
was
chat.
at work.
Yes, I was just trying to make it clear because you could FaceTime audio. So it was the FaceTime
It
video.
was, we were
Correct.
talking face to face on
Okay.
video.
And you had told Mr. Marin well on FaceTime, you had showed him that you were at Lake Lansing. Is that true?
That's true.
Okay. And you had indicated you did not, I'm not saying you misrepresented it, but you did not indicate to him that you were there with anybody else. Isn't that true?
No, I didn't, because he had a lot of issues with jealousy. Anytime I shot with a male photographer, things like that, I didn't want to fight.
Okay, so you had told him I'm at Lake Lansing and you had indicated to him that you were alone, right?
I did not indicate either way if I was
Okay.
with someone or not.
You didn't indicate one way or the other, but
That's true.
it would have been fair for him to believe you were alone up at the lake, true?
Your Honor, I'm gonna say speculation at this point.
I'll move on, Your Honor. I think I agree with that. So
But I didn't invite him.
I understand you didn't invite him, but you indicated to him that you were up at Lake Lansing, right?
That's true.
All right, and Lake Lansing is a public beach, true?
Yeah, we just had a lot of bad memories there.
You said you had a lot of what?
A lot of bad memories there. I take my support out there.
Did you say you're subboard?
Yeah, it's what I
Like
do
stand
yoga
up?
on.
Okay, me too.
So,
Um,
just had bad memories. I like it being my peaceful space when I go there.
okay, I understand. You didn't invite him, but did you, I guess, let me ask a better question. You guys didn't talk about whether, like, it wasn't, you didn't think he would come up there, you thought he was working, it wasn't discussed whether, you didn't tell him not to
Never
come
a
up there.
discussion about him coming there, but I have asked him to leave before when I've done it.
Okay.
Because I don't want it to mess with my peace if he's gonna act in ways that are not appropriate or peaceful.
Okay, I hear where you're coming from. On that particular day of August 16th, you didn't tell him not to come up, nor did you tell him to come up. The conversation of him coming up there was no conversation.
There was no
is that-
conversation. He texted me later that day. I thought you'd be excited that I surprised you.
Okay,
Yeah, but when we did talk, I did ask him to leave.
okay. So he got up there. You were doing some paddleboard yoga.
No, I wasn't.
Or I'm sorry, did I miss?
I just
no.
had a therapy appointment, so I was walking back from the therapy.
Was it like a
appointment.
Zoom
It was just over the phone.
over
Just
the
a
phone?
call.
Okay. So you had a phone call, you were walking back. Philip is talking to Aaron, is that
That's
correct? Okay. Have they ever met each other?
No, he didn't know who he was.
Okay, so how did Aaron end up talking to Phil? You know?
I just walked up to the conversation. I don't know what the conversation was before I walked.
Okay, and you don't know how okay, fair enough. And eventually you asked Phil to leave.
It wasn't eventually, it was pretty quickly.
You had asked Phil to leave.
Yes, I did more than one.
Okay, and Phil left, true?
Yeah, he had walked away and walked back up. So he didn't leave initially,
But he did leave.
but he did leave eventually.
Okay. And during this particular time at Lake Lansing, Phil did not attempt to assault either you or Aaron.
Not at all.
Okay. Now, Marlette, regarding the incident that took place on August 17th, the early morning hours of August 17th, which is what you testified to today, Do you believe that your memory of this event has gotten better, like today, than it was right afterwards when you talked to police, or do you believe that it's
I
faded
think
over
it's the
time?
same.
The same? Okay. And so when you spoke with police on August 17th, did you understand that it was important to be truthful with the police?
Yes, I was truthful.
Okay. And you understood the importance of trying to get your details correct, right?
That's true.
And that like this would likely be going in a police report, and
Absolutely.
that you want to make sure that you're as descriptive and specific and truthful as possible. Would you agree with that?
I do.
Okay. All right, so I apologize to make you go through this a second time, but I just have a few follow-up questions about
Sure.
your direct testimony. So you wake up to like your light. I guess I didn't ask the question. Were you sleeping when Phil entered your room?
I was falling asleep. I wasn't falling asleep.
Okay, and approximately what time in the morning was
I
this?
think it was around 3:30.
3:30 in the morning. Okay. And just to be clear, I know there's been some issues, but you and Aaron went out to dinner that night. Is that true?
No,
Okay, you didn't? I thought I heard
We
that on
got
direct, and maybe I got it wrong.
we DoorDashed.
Oh, you DoorDashed food. And had you guys had any alcohol to drink? I know you were celebrating his birthday.
No, he stopped drinking. He was with me and he's been sober ever since.
Aaron stopped drinking when he was with you? Is that what you said?
During the
I'm
time
sorry.
we hung out, there was no drinking. I do not drink.
Okay. So there was no drinking. Did you guys use any like cannabis or other drugs?
No, I'm in
Okay.
sobriety court. I don't drink or do any drugs.
Okay. And so both of you guys were completely sober
That's
on the night of this
100%
incident.
accurate.
Okay. And so you wake up to Mr. Marin turning on the lights, or kind of, you said you were falling asleep. So the first thing you notice is the lights turning on. Is that fair?
And him staying there
Yes, those two things, right?
at the same time.
At the same time. Okay. And then he's just asking to speak with you at that time. True?
That's true.
Okay. At that time, he's not attempting to assault you. Is that true?
There was no attempt to assault.
Okay. Is it true that he wasn't trying to break any of your property or anything like that? At that
I
time.
don't know how, not that I know of.
Okay, fair enough. We're only asking you to testify to what you know
Yeah.
about.
And the door was unlocked, so he didn't break the door.
So he didn't break the door, he didn't break any of your other property, and he didn't try to assault you.
That's
Fair?
all correct.
Okay. And he's asking for your time, right? Or to talk to you, but inside of your apartment. True?
Yeah,
That's what he's asking for. And is it fair to say he's begging for that at this point?
yeah, and I was very firm that I did not want to talk to him.
Okay. And so you indicated to Phil that you did not wish to talk.
I said, you need to leave,
You need to leave.
over and over again.
Okay. And then Aaron came into your bedroom, true? And kind of took your back with that request to
Yeah.
leave. Is that
Yeah,
fair?
he just said, she's asked you to leave, and you really need to leave.
Okay. And is it true that inside of your bedroom that Aaron shoved Phil?
I wouldn't know, honestly, but I don't have a recollection of that.
Fair enough. So you don't remember?
Shoving Philip?
Yes. Aaron shoving Philip, that's what I'm asking about.
No, I don't.
Okay.
I just remember getting out of bed. And then walking towards, he was in the doorway a bit. And walking with Aaron and him towards the front door.
Okay, so you guys walk towards the front door. Do you remember Aaron giving Phil a shove in his back as you're walking towards the front door?
I don't. I could have, and maybe I didn't see it.
And then when Phil
I do know he shoved him later,
Okay.
after we got to the front door, and they kind of went face to face with each other.
Okay, well, we'll get to that part of the story, and, you know, it's completely fair. Memories aren't perfect. When you say you don't know, you know, I mean, it's okay
Yeah,
that
I'm
you don't
just being
remember certain
100%
things.
truthful.
Yeah, and I appreciate that very much, and that's obviously what we're here for today, is to get the truth. So as you get towards the front door, Philip is walking towards the front door, is that true?
Yeah, he walked with us towards the front door.
Okay, and then it's correct that Aaron, I think you were getting to this part of the story, that Aaron had shoved Phil.
Let's start at the beginning of getting to the door.
Okay,
Okay, so he wouldn't walk out the front door when we were asking him to leave. Philip.
okay, and
So
he
then
was
he
continuing to
turned
ask.
Towards
I'm sorry.
Mr. Bedell. You want me to continue or stop?
I guess let me just ask a follow-up
Sure.
question, if that's okay. So you getting towards the front door, and Philip turns around and he says, like, just give me 2 minutes. Is that correct? Or something like that, continues to plead for
Yeah,
time,
and I said no.
and you said no. And then at some point, Philip and Aaron kind of get close face to face. Is that fair?
Yeah, after Aaron said, I've known Marla for 15 years, she's asked you to leave, you need to leave. Then Philip got in the face of it. I don't remember seeing him during punch at all.
Okay, and you do
But
remember
just kind of
just getting close.
like
True.
chest to chest. Yeah, face to face.
Okay, and then from there, you do remember Aaron shoving Phil. True.
Hitting him first.
And
then
hitting him.
shoving.
Okay, so he hit him first, then shoved him.
Yeah.
Okay. And then at that point, Phil was out. Correct, he like kind of rushed him out of the
Pushed
apartment,
him.
pushed him out,
Yes.
Okay. Pushed him, shut the door. You went into the bathroom. Is that true after that?
I was not in the bathroom when Aaron went on the balcony and was talking to him and Phil went in his truck. I was still in the living room area for that.
Okay, so I just want to be
I
clear,
did go to the bathroom after while he was, the police were on their way.
and just to be clear, during this whole incident, while Phil was in your apartment, you don't have memory of Phil attempting to push Aaron at any time. Is that true? Like, you don't remember?
I
a
don't
push?
remember that.
Okay.
I don't remember either of them pushing each other at all before getting to the door.
Okay.
But I also turned and got out of bed and walked towards my doorway.
Yeah, and I'm just,
Yeah. But
Marla, I'm not
100%
trying
I
to-
don't remember.
yeah, I'm just
that
asking you
part.
what you remember.
Yeah.
So the only,
If one of
alter-
them shoved each other, I didn't see it.
okay, so just to be clear, the only physical, like, touching that you remember as you sit here today was Aaron making contact with Phil's face and then
Well-
shoving him out of the
well,
apartment.
Yeah, but after I asked him to leave, Philip, went chest to chest with him,
Okay.
got in his face.
Yeah,
So
and I'm
that
just
was
trying,
the first initial contact that I saw.
okay, so you saw Phil go towards or get in his face, right? They got close face to face, but as far as
They were
physical
touching me chest
push,
to chest.
as far as a push
Yeah, I
or
did
a
not see
punch,
a-
the only one you saw was
Not that
Aaron.
I remember, but I was very overwhelmed.
Okay, and that's fair. I'm only asking you to testify to what you remember, okay?
Okay.
I just want to make sure we're clear, we can kind of get out of this apartment. During the time that Phil was in the apartment, you don't remember him, you don't have memory of him shoving or attempting to hit Aaron, true?
Right, this is absent answer at this point. She's already described this.
She's already answered it. We can move on.
Okay, we can move on. I was just trying to kind of tie it up in a bow, Your Honor, with a more comprehensive question, but I'll move on if Your Honor wants to.
It's not even an element of the crime, so we can move on.
Your Honor, an assault is an element of the crime in the manner that the people are charging the home invasion. As far as what the
Is
people.
that
have-
correct?
Assault, yes, yeah.
Assaulting the last witness?
Assaulting the last witness, Your Honor.
You can continue.
Okay.
So, what was the issue?
It was just brought to my attention that the witnesses can likely hear my questioning while they're outside. And I think it was brought up to my attention because they're sequestered. I don't think that's anybody violating a sequestration order that they're in the hall. I don't know what the proper procedure to deal with that.
I mean, so the issue is that we have paper thin walls here, so I can hear everything Judge Flores says word for word in here. So it just is what it is. We could have, if there isn't a room available, we can have the witnesses removed to a room if one of the prosecutors can assist with that and get them into a room.
Okay, and thank you, Your Honor. This is my first exam in front of Your Honor. I feel like with these
Yeah, this
paper thin
courtroom,
walls.
it's quite common. Those are fake walls. They're hollow.
Fair enough. It was just brought to my attention, so I was bringing it to Your Honor's attention. Okay, and then to your knowledge, Marlette, once Philip left, there were some like words exchanged on the porch.
Mhm.
To your knowledge,
On the balcony.
on the balcony, but Philip wasn't on the balcony. Philip was on the ground, like
Aaron
leaving
was
the
on
apartment.
balcony.
Yes, and to your knowledge, the words exchanged, none of those involved Phil making any threats towards Aaron. Is that true?
I didn't hear what Phil was saying.
Okay.
He was all the way down at his truck.
What was Aaron saying to Philip?
Objection, Your Honor, hearsay.
It's not for the truth of the matter asserted, Your Honor.
Something along the lines of never to come back. to my truck, which I understated.
Okay. So Philip was Aaron was telling Philip, don't come back.
That's correct.
That's like the nature of the conversation.
Yeah,
Okay. And you couldn't hear what Philip said.
I really couldn't.
After they left, you were not the one that called or that Philip left, I'm sorry. You were not the one that called the police, Aaron was.
That's correct.
Is it safe to say that as you were waiting for the police to arrive, that you and Aaron had discussed what just happened a little bit between each other?
I was shaking. He asked me if I was okay.
But did you guys discuss like the details of what just happened?
No, I feel like it wasn't until we were being interviewed by the police that, they separated us. I was downstairs towards the main entry and he was upstairs.
Okay. And isn't it true that you could actually hear the details that Aaron was giving to the police?
It's true.
And you actually would like yelled up to him to correct when he got some details wrong?
There was a discrepancy with details.
Okay. And so you wanted to make sure he got his details correct when he talked to the police, true?
He said he punched Phil from the face and he said he slapped him. That was the discrepancy.
Okay, but I'll move on. I have no further questions, Your Honor.
I have a couple. I'm not clear on what's going on with the Lake Lansing situation. So you all were broken up on the date that you were at Lake Lansing, but you all were still talking, correct?
We had talked while I was there.
Okay, and you initiated that communication?
I did.
Okay, and was the communication a pleasant one, or were you all fighting?
Yeah, I was asking him how he was doing.
Okay, so it was a pleasant communication, and you shared with him where you were?
Yes, I did.
Okay, but you didn't tell him not to come up there, correct?
I didn't say to come or to not come.
Okay, and so then, well, I think that answers my other question, because I wanted to know how long how he knew you were there. And then how long after the phone call was it before you saw him there?
Probably, well, my counseling appointment's an hour, so probably 2 hours.
Oh, so 2 hours later he shows up. Okay.
Maybe an hour and a
Redirect.
half. Yeah.
Yes, Your Honor. During that phone conversation with Mr. Marin, did you give him permission to come to your home?
I did not.
Any point in time that day, did you give Mr. Marin permission to come to your home?
No, not at all.
Thank you. Nothing additional. No.
Let me just follow up on that. So prior to this date, in question, when was the last time you recall that he was in your home?
I really don't know. Weeks at least.
Oh, it had been weeks since he had been in your home. Okay, thank you. Any redirect based on my question?
Yes, Your Honor. Actually, no, Your Honor, nothing. additional.
May I have just one question, recross?
Yes.
Do you know how long it had been since you had been in his home?
I really don't.
Okay. Was it also weeks or was it more recent that you had been in his home than he had been in yours?
I would have to look up the date. I went to a martial arts self-defense class. Was the last day that I had came over. And I could see the date of that on the pictures I took with other girls I took the martial arts defense class.
And I guess what I'm getting at, and you don't need, if you don't know, you can
I
just say,
didn't think
don't
I was
know.
gonna be asked
Yeah, and-
questions like that.
Fair enough. I just, based on the judge's question, I was just trying to get, was it more recently that you had been in his house than he had been in your apartment? Is
I
that
really
fair to
don't
say?
know.
You don't know. Fair enough. No
Yeah.
further
And I
questions.
don't want to say one way or the other and have it be incorrect. I would have to look at our text messages.
Very well. I have no further questions, Your Honor, and defense. Actually, you're not calling. I'll let you go first.
You've already completed your redirect, so I just want to let you know that there is a sequestration order, so you're not allowed to discuss any portions of your testimony with any other witness, okay? Okay, you may be excused. You can call your next witness.
At this point in time, Your Honor, the people would arrest.
Thank you. Are you calling witnesses today?
Defense rest, Your Honor.
Okay, you can make argument.
Yes, Your Honor. As Your Honor is aware, this is a felony complaint. Mr. Marin has been charged in count 1 with home invasion 2nd degree. And then there are 2 misdemeanors, an assault and battery, as well as the stalking domestic relationship. As I had stated previous to arguments, Your Honor, the case number that is 25-3225-SM, which is a domestic violence in a stalking matter, we would be moving that domestic violence into this case, Your Honor. As it is a misdemeanor, we would just be binding it up with the complaint in and of itself. For purposes of preliminary examination, we are just binding over on the felony charges. As I stated, the felony is a home invasion 2nd degree. We would actually be amending it to a home invasion 1st degree, Your Honor. The elements for home invasion 1st degree, there are 4. The first being that the defendant broke into a dwelling. It does not matter whether anything was actually broken, however, some force must have been used. Opening a door is an example of enough force to count as breaking. The second element, Your Honor, is that the defendant entered the dwelling. The third is that when the defendant entered, was present in, or was leaving the dwelling, he committed the offense of assault and battery. And the fourth element, Your Honor, is that when the defendant entered, was present in, or was leaving the dwelling, either of the following circumstances occurred. Specifically, we would be saying that another person was lawfully present inside of the dwelling. In regards to the first element, Your Honor, in regards to the breaking, you had heard from Mr. Bedell that he woke up to the defendant who would have had come in through the balcony, jumping over him with that door being right there. You heard that that door was unlocked and the defendant needed to, in order to be in that position, to have climbed up to the 2nd floor balcony and entered through this door, Your Honor. Therefore, we have met the first element. The second element is that the defendant entered the dwelling. As you heard from both Mr. Bedell and Ms. Wallace, the defendant was inside the residence that day. You had heard from Ms. Wallace that she had not given the defendant permission to be in the residence at that time. You had heard they had actually been broken up since the end of July. Therefore, we have met that element, Your Honor. In regards to the third element, the defendant entered, was present in, or was leaving the dwelling. He committed the offense of assault and battery. Your Honor, there is 2 jury instructions for assault and battery, those either being where a battery was shown or where a battery was not shown. I would be arguing, Your Honor, that there was a battery in regards to what Mr. Bedell stated. The elements for assault and battery being that the defendant committed a battery on Mr. Bedell, a battery being a forceful, violent, or offensive touching of the person or something closely connected to the person of another. The touching must have been intended by the defendant, that is not accidental, and it must have been against Mr. Bedell's will. It does not matter whether the touching caused an injury. And the second element being that the defendant intended to commit a battery upon Mr. Bedell or make Mr. Bedell reasonably fear an immediate battery. You heard from Mr. Bedell, Your Honor, that while Mr. Marin was inside of the residence, he did, while Mr. Bedell was trying to get him out of the apartment, ended up actually looking back and swinging at Mr. Marin or at Mr. Bedell, swiping his nose, Your Honor. An action like that, Your Honor, is very clearly an intended incident based off the incident that was happening. You had heard from Mr. Bedell that they had already been pushing and that Mr. Marin was not willing to leave the residence at that time. And a swing to someone's nose, Your Honor, is very clearly a forceful, violent, or offensive touching of another person. I understand that Ms. Wallace did not testify in regard to an assault, but as you had heard, she was caught up in everything. She wasn't able to see everything very clearly. Mr. Bedell was the one that actually experienced this incident. So we believe that we have met that element. And then the fourth and final, Your Honor, is that the defendant, while the defendant entered, was present in, or was leaving the dwelling, that another person was lawfully present inside of the dwelling. And you heard from both Mr. Bedell and Ms. Wallace that this was Ms. Wallace's residence and that Mr. Bedell was lawfully staying there at the time of this incident, Your Honor. That being on the night of August 16th to August 17th of 2025, that apartment being at 825 South Washington Avenue, City of Lansing, Ingham County, State of Michigan. So we believe that we've met the elements in this matter, Your Honor, and we ask that you bind over on these amended charges of home invasion first and let the misdemeanors follow. Thank you.
Your Honor, I would object to the bind over on the home invasion first. I think that Your Honor has the ability and obviously has been doing it for a long time to assess credibility. And what you heard here, there's certainly you heard evidence regarding probable cause of an unlawful entry or entry without permission. Certainly, you heard that evidence today. But what you didn't hear credible evidence on was an assault. And as the people just did a great job going over the elements that is their theory of why this is a home invasion first. Your Honor, I'm sure, I know Your Honor is aware, although this is my first preliminary exam with Your Honor, that when you're looking at probable cause, you're looking at the likelihood of a conviction beyond a reasonable doubt, whether there's probable cause that there would be a conviction. In this case, what you heard was Mr. Bedell admit to assaulting Mr. Marin multiple times before he claims that there was a swipe thrown at his nose, that it just grazed his nose, but of course that there would have been no injury for the police to see. And to knowing that that's what you needed to defend the fact that he punched Mr. Marin in the side of the head. And what you heard from Ms. Wallace is that she didn't see Mr. Marin place a hand on Mr. Bedell. What she did see was Mr. Bedell punched Mr. Marin in the face and that she saw him shove him multiple times. Mr. Bedell also admits that he shoved Mr. Marin multiple times before leaving the home, and that Mr. Marin never made any contact with him besides this supposed swipe. I find his testimony regarding the punch that grazed his nose to be incredible. I think Your Honor should find it incredible. It's not in line with what Ms. Wallace remembers. It's not in line with what Ms. Wallace saw. Ms. Wallace was certainly in a position to have seen it based on her testimony at the time. She said she's the one that says she remembers it as well today as she did at the time of the incident. Well, Mr. Vidal said his memory has gotten worse since the time of the incident. So he admitted to his memory has faded. So I believe that Ms. Wallace's testimony to be more credible. And Your Honor, I would just like to know that self-defense is something that can come into play even when you are not on legally in a place. And I would just like to note a couple of cases for the record. I'm sure Your Honor is well aware. People v. Ogilvy, 341 Mich. App 28, which removed the traditional common law duty to retrieve. And Your Honor, People v. Towns, 391 Mich. 578, which indicates and it goes over the issue of self-defense in a position when you're sort of in the wrong in the first place. And it indicates, but the wrong which would preclude him from making that defense must relate to the assault in resistance of which the assailant was killed. And what that case really goes over is the fact that even if you are wrongfully in a place, if somebody assaults you and the assault is not related to the wrong, then you still have a right to defend yourself. Here, Mr. Marin was at the door. He was not assaulting anybody. He was not breaking any property or anything like that. And Mr. Bedell admits that he shoved him multiple times throughout this. So even if Your Honor were to believe the testimony regarding the swipe, which I stand by is incredible. But even if Your Honor were to believe that, I believe that under the case law of People v. Towns, as mentioned, I would also mention one final case, People v. Riddle, 467 Mich. 116, which kind of goes over the same right. That even if you found the testimony credible, that he had a right to defend himself from the assaults, multiple assaults that had taken place on him before that. So for those reasons, Your Honor, I believe I object to the bind over, and I would ask for you to dismiss that particular charge for lacking probable cause of that element. Thank you.
Any further argument?
Yes, Your Honor. The assault was clearly related to the wrong, Your Honor. Mr. Marin was unlawfully in the apartment at the time of the incident. Any assaultive behavior that Mr. Bedell would have done was to prevent that wrong of Mr. Marin being inside of the residence and trying to get him outside of that residence, because Mr. Marin was clearly not leaving. He kept begging, please, please, let me talk, let me talk, let me talk, and did not leave until there was this contact that had happened. Additionally, Your Honor, the definition of assault, there's a definition of assault for even if there was no battery, which there were assaults where there were no battery either, Your Honor. And those assaults being that Mr. Marin ran up on Mr. Bedell multiple times with his hands up, running toward him in an aggressive manner, getting right up face to face on multiple times, Your Honor. That definition of assault where there is no battery being that the defendant either attempted to commit a battery or did an act that would cause a reasonable person to fear or apprehend an immediate battery, Your Honor. And the second being that the defendant either intended to commit the battery or to make that person reasonably fear an immediate battery. Your Honor, the only other reason that Mr. Marin would be running up on Mr. Bedell, getting right up in his face, holding his arms up in an aggressive manner, not with fist up, but holding his shoulders up, as you heard Mr. Bedell say, is clearly a action that a reasonable person would fear or apprehend an immediate battery if someone that was not supposed to be in the residence ran right up on you, Your Honor. So even if the court does not believe that a battery did occur, there was still an assault, Your Honor. So I'd ask that you bind over. Thank you.
Okay, today's the date scheduled for preliminary examination. The burden is on the prosecution to establish if they have sufficient probable cause that the felony that you're being charged with was committed, and there's sufficient probable cause to charge you as the individual who committed the felony. This is not a trial. They don't have to prove each element beyond a reasonable doubt. They just need to establish more than mere suspicion that the action alleged took place. And so, as your attorney has indicated, I am going to be the sole determiner of any credibility issues. And I'll take the information and evidence as is provided to me today. It's a flexible burden, and so it can be based on circumstantial evidence. We have here a 3-count complaint, count 1 being a felony originally charged as home invasion 2nd degree. The people are asking to amend that to a home invasion 1st degree, and they've gone through those elements. The first element, which I believe your attorney even concedes, again, is that the defendant broke into a dwelling. Again, it doesn't matter whether anything was actually broken. You just had to use some level of force. So if it was a closed door and you open the door, that's enough level of force to satisfy the element there. Second, that the defendant entered the dwelling. Well, the testimony that we had here from an Aaron, is it Bedell?
Bedell, Your Honor.
Aaron Bedell testified that on or about August 16th, 2025, he was present at the address of 825 South Washington Ave in the city of Lansing, Ingham County, which makes venue in this court appropriate, that he identified the person in the court today as Philip Marin as being present at that location or the early morning, late night, while they were sleeping. And that he testified that he was awakened by the defendant coming through the 2nd floor awning, which he described to be the area near the balcony of the back of the home. When questioned, he testified that there was no staircase or stairway to get into or onto that balcony area, and that you had to scale the side of the house in order to get that. That's possible. It's also possible a ladder could be used, or, you know, you could have had a drone drop you off. We don't know, but we know that there's no staircase there, and that the victim, or the witness, I should say, said he's witnessed the defendant coming through that window, and he said jumping over or leaping over the couch sectional area, which the witness was also present sleeping on at the time. He stated that was the second time actually meeting or seeing, I should say, the defendant, and so that was how he was able to identify him. And so I think the second element was satisfied through that level of testimony there. The third element, which is that the defendant entered, was present in, or was leaving the dwelling, he committed the offense. In this case, the people are relying on what is charged as count 2, assault and battery upon Mr. Fidel. Your attorney believes that there's a lack of evidence to support that there was actually an assault or assault and battery, and that maybe there's a credibility issue. To be quite frank, I did not find any issues of credibility with Mr. Fidel. I thought his testimony remained consistent. Whether or not the series of actions aligned exactly how it went, I'm not sure. That I think that was a little gray as to what took place, what time frame it took place. And I think that although I also found the victim in this matter, or the alleged victim, is Marlette Wallace, her testimony to be also credible, I think she was clear that she was overwhelmed. She had a lot of things going on, so she's not necessarily paying attention to who hit who first. What Mr. Bedell testified to was that he was charged, is what he said, or that the defendant rushed him in an aggressive way or a combative way, in a way to intimidate him. And he's testified that he was intimidated. That right there is enough for an assault. Doesn't matter if he was grazed in the nose at that time, or if there was, or if after being rushed, he felt the need to swing. Well, that gives, I think he gets to rely on the self-defense there, because he felt like someone was rushing towards him, and he gets to take the situation as he sees it there. He felt like he was at harm. He said that there at the time, Mr. Marin was going through a range of emotions, being both combative and aggressive, and then switching to being nice. And then also he testified that Mr. Marin, he smelled alcohol, so he thought maybe he might have been under the influence. And so I do believe that there's sufficient evidence to support that Mr. Bedell believed he might have been in danger of an assault or assault and battery at that time. Lastly, even Miss Wallace, when she testified, she did indicate, even in her testimony, that it was Mr. Marin who went chest to chest, is what she says. She didn't say that the victim approached him. She says Philip went chest to chest with the witness after he was asked to leave. And so that again demonstrates that the defendant was the one or the aggressor in that exchange between him and Mr. Bedell. Where or how it got to the blows is not for me to determine, because if I'm trying to, if you're asked to leave and then you approach me in an aggressive nature, I'm probably going to hit you too. And so with that being said, the court is satisfied that there's sufficient probable cause to bind over count 1 as amended to home invasion, first degree breaking and entering. I believe there are some questions of facts as to the nature of the actual assault, but we'll leave that to a jury to determine. And so your bind over date is going to be November 12th. That is the date the circuit court receives the file from this court. It's not.
That's not the arraignment date.
Correct. Well, you're essentially, it's essentially arraigned in this county unless you make a motion to have him rearranged. So he does not have to appear.
Oh, we don't have to. Okay, so there's no date of the 12th. I'll just. check.
Correct. You do not need to appear. Our county has an order where that's hereby the second arraignment is considered waived unless you make a motion for a new one.
I am not making said motion.
Right. So after which date, there will be a new court date for a pretrial and your attorney will be made aware of that, okay? Do you have any questions at this time?
I do not, Your Honor.
Again, we will make sure that the teller company receives a copy of the order. I do also think that the language might need to be changed, because it could be confusing. Do not be within 2,000 feet of where Ms. Wallace lives, works, or goes to school. Okay, I'm going to have the second sentence changed to defendant is allowed versus in a negative. Defendant is allowed to work at People's Kitchen except on Mondays.
Perfect. Thank you very much, Your Honor.
Okay, so we'll make sure that that's corrected and sent over to the GPS tether company today. Any additional matters for the record?
Just a point of clarification, Your Honor. I know I brought it up previously, but I just want to clarify that the people do plan on taking the domestic violence in 25-3225-SM and attaching it to this case at bind over. So we will be attaching this to the complaint as well.
I guess, can I ask a question related to that? It's not
Yes.
officially part of this case. We have a scheduled pretrial. I have a scheduled pretrial with Your Honor regarding those 2 misdemeanor cases. It sounds like the people are gonna make some sort of movement to combine these 2 cases and bring that up to circuit court. So I guess I'm just wondering about our
So
court date on the November.
You're saying
3rd.
that the domestic violence was an incident from August 16th?
It is not from that same date, Your Honor. However, it is in relation to the stalking misdemeanor that is going up to circuit court. And that's why I believe it would be appropriate to combine these 2
So
cases.
you want to add what 2 counts?
I would be adding a count of domestic violence, Your Honor. There was already a count of stalking on this current
Okay, but
case.
I guess what I'm asking is, we have court on Monday for this misdemeanor case.
Correct.
Is the intention to bind over that case on Monday up to the circuit court with the?
No, add it now and
Correct,
then.
add it now, and
you
then I
don't need
would
to
be
come on
submitting a
Monday.
nollie in the misdemeanor file.
Okay. and
So we would not need to be present for the pretrial next week.
Okay, that's what I was trying to get at. Thank you.
Okay, okay, so let's see,
So that would be a added count.
4.
Yeah, technically, I guess 5, Your Honor, since the aggravated stalking was technically count 2. I know it was denied.
What I don't know that he was he ever arraigned on that?
I don't believe he was, Your
Then
Honor.
it's
So
not
maybe,
count
okay.
2. You all just needed to amend the.
Then
I
count
Right,
think
that
that
didn't happen.
to get information, because I had.
Yeah, it says in red here denied, so On our file, I believe it has it in count 2 as the assault and battery. This is what they wrote here. Assault and battery, count 2, yeah. And then count 3, stalking, correct.
Okay, so then adding count 4 would be the domestic violence. And then we would we would make count 5 the home invasion first, and we would dismiss count 1, the home invasion second.
No, we'll just amend count 1 to home invasion first.
We'll do that then. Yeah.
And add count 4 of DV and dismiss, you're gonna nolly this, what's the case number? there?
That is 25-3225-SM.
I think someone provides you a nolly, is that correct?
Yes, that is correct, Your Honor. I'm signing it right now and submitting it.
On us. Otherwise will be continued. Let me get you a copy of this, Molly.
Are we on? So. Oh. Are we off the record, Your Honor?
Yes.
Your Honor, I just wanted to say it was a pleasure. I know it was over my objection for discovery reasons, but it was my first exam in front of Your Honor.
No problem. It was a pleasure here too. And best wishes to you. Thank you.
Thank you, Your Honor. Oh, I don't know if we need it for the record, but there is no plea offered at this time. It would be sent up to circuit court for global resolution of regards to all the clients.
Sounds good.
Thank you.
Thank you.
Have a great day, everybody.
Have a good one. And then we have Mr. Kristen here. Is that correct?
Yes, Your Honor.
Correct.
And we're running that.
Yes, Your Honor.
Everybody's talk.
Right.
Ready?
Yes, ma'am.
Yes, Your Honor.
On the record in the matter of the state of Michigan versus Anthony Kristen 25-03117, appearance, please.
Jeffrey Billabell on behalf of the people, Your Honor.
Thank you, Your Honor. Robert Palmer of the Public Defender's Office on behalf of Anthony Bryson Jr., the gentleman who's seated to my right, also with me, President Council table, if it's okay with the court, is Georgia Nid, also at my office.
It's not okay. Amid's gotta go across the hall. No problem.
I could be, I'm just gonna be listening. that's all.
No worries. Okay, and so we're ready to run the examining preliminary matters.
Yes, Your Honor. Just for the honors, for your honor's knowledge, I think I have enough to bind over today, but depending on how testimony comes, we may have to ask for a continuance. I'm just not sure. I'm certainly not studying a preliminary exam knowing 100% I'm not gonna get it bound over. But I'm not sure how the testimony will come, depending on whether the elements have been met for me to be able to bind it over today, Your Honor.
Sounds good.
Mr. Billabay did advise me of that. We did equal to the proofs. We'll see what happens. My only preliminary matter is I would just ask for sequestration of witnesses. Appears it's already happened, but
We'll have two witnesses, Your Honor, and of course, we'll comply with the sequestration, Your Honor.
Sequestration is granted. You can call your first witness.
Thank you, Your Honor.
The substance abuse assessment could be added to the file. solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
You can have a seat. State your first and last name and spell both.
First name is Owen, O-W-E-N, last name is Rogus, R-O-G-U-S.
Officer August, how are you employed?
I'm employed through the Lansing Police Department.
And as a, what do you do for Lansing Police Department?
I'm a patrol officer,
And as a patrol officer, what are some of your day-to-day duties?
responding to calls for service, traffic stops, things like that.
Okay, I want to take your attention to the events that happened on October 14th, 2025. Do you remember that day?
Yes, I do.
What of significance happened on that day that brings us to this courtroom today?
I made an arrest for a bond violation.
Okay, and was this a dispatch?
Yes,
What was the nature of that dispatch? Oh, you bond violation. And who was the subject of that bond violation?
do you mean the victim or the accused?
The accused.
Anthony Prison.
Okay, and where did you go when you got that dispatch?
I originally went to the address of the call, which was on Duvernay Drive, apartment office, where the manager called saying that he had called trying to find his.
I'm gonna object to hearsay.
Effect on the listener.
Oh,
Go ahead.
I was dispatched to the apartment complex because the manager said that Mr. Prison called looking for his girlfriend or his former girlfriend.
Okay, and do you know the name of this girlfriend?
I can't remember off the top of my head.
Okay, and when you arrived there, what did you do next?
I contacted her after I spoke to management about the issue.
Okay, and you were able to see her?
I was able to call her. I made phone contact with her because she wasn't at the address at the time of the call.
We
Okay.
just for clarification, who is, when we say her, who are we referring to the complaining witness or the
or the,
manager or
manager.
somebody else?
Yeah, who are we talking about when we say her?
The ex-girlfriend, my apologies.
I don't know, there's some people just joined, I just want to make sure there was no witnesses in the court.
No, these
Okay. Thank you.
victim advocate. And this is the girlfriend?
Correct, the ex-girlfriend I called after I spoke with management.
Okay, and then what did you do next?
Then I called JSG Monitoring because they're the type of company that I believe Mr. Prison was using.
Okay, and did you learn that there was a bond placed at that time?
I knew, I had prior knowledge. I took a bond violation report earlier in the month for the same issue.
Okay, and I'm going to show you what will be marked as people exhibit 1.
You looking to mark an exhibit, you went the wrong
Yes.
way.
Oh. Is this the bond violation that was put in place?
Yes, it was.
And when was it signed?
It says it was signed on. Sorry, find it. His date of arrest, which was 4/13/24.
Okay. So you wanna, oh, I didn't enter it to defense. Sorry.
I get it.
You wanna, given that this is a copy of the order that was signed by magistrate, and it's a true copy of the order, the people move to admit this as a self-authenticating document.
No objection.
Assume it's the same order that's already in the file.
I'm sorry,
Assume it's the same order already in the file.
that is correct, Your Honor.
Right.
I'll take notice. Thank you. It's
Thank
admitted.
you. And just giving you back this order, can you tell us what provision Q says on the order?
Provision Q says, do not harass, intimidate, beat, molest, wound, stalk, threaten, or engage in other conduct that would place any of the following persons or a child of any of the following person in reasonable fear of bodily injury: spouse, former spouse, individual with whom the defendant has a child in common, resident or former resident of the defendant's household.
Okay, but reading that order, do you see the person who the defendant was prohibited from doing any of this to?
I'm sorry, can you?
Do you see the name of the victim the defendant was supposed to?
Yes, I do.
What's her name?
Sierra Thomas.
Okay. And does that reflect your recollection to
Yes,
who
it
the
does.
victim was?
Yes, it does.
Okay. So let's go back to JSG monitoring. you learned, you contacted JSG monitoring. What did you do next?
I asked where the tether was currently located, and it showed at an address on South
Again, I'm
Cedar.
gonna object to hearsay, Judge. What do you learn from JSG?
Effect on the listener, Your Honor. It tells how he ended up getting there as part of why he ended up getting arrested in violation of this order.
Objections overruled.
Go ahead.
I contacted them to find out where he was currently located, and it showed him at 4700 South Cedar Street.
Okay, and is that the area that he's not supposed to be?
No, that was his place of employment. The reason I contacted JSG was because of the violation for trying to find third-party contact with the victim.
Okay, and this happened, do you remember the date of this incident?
It was the same date as the report was taken that day.
Okay, and what did you do next?
After I went to McDonald's, I located Mr. Prison at the front of the McDonald's and placed him in custody.
Okay, and did you do anything else?
Not that I can remember, no, besides booking him in.
Okay, and did you search him?
I did, yeah.
And what did you search?
I searched his person because I took custody over him. So I searched on his person all I.
Okay, and what did you find?
I just found vape, a cell phone, a wallet, things like that.
Okay, did you find anything of evidentiary value?
Not, I did find his cell phones. I collected those, just to him calling and possibly texting Sierra Thomas.
Okay. Did you do anything else as part of your involvement for this case?
Nope.
And once you took him in custody, did that conclude your involvement with this case?
Yes, it did, and completing the report, obviously.
Thank you, Your Honor. That's all the questions I have.
Thank you. Good afternoon, officer.
Good afternoon.
I just have a couple of quick questions for you. You indicated, and to be clear, I'm not asking you what was said, but you indicated that you went to the apartment complex, is that right?
Correct.
And you talked with an apartment manager.
Correct.
And you learned about a phone call that was allegedly made. Again, not asking you what was said, but you learned about the phone call.
Correct.
Was the apartment manager the person who actually received the phone call?
No, sir.
All right. Did you actually, you personally, talk to the person who received the phone call?
No, sir.
And then you went through, I guess, information that you learned from JSG, you went and you arrested my client at his place of work.
Correct.
And I think, I don't mean this as a trick question. So, but I think you said at the time, at least, you were investigating a potential bond violation.
Correct.
You were not investigating, at least to your knowledge, at that time, you were not investigating a separate crime.
At that time, correct.
Thank you. I have no further questions.
You know, just one more. You were investigating a bond violation that defendant had committed on that day. Is that correct?
Correct.
And you're the police officer who arrested defendant on that day?
Correct.
You see defendant in this courtroom today?
Yes, I do.
Can you please point and identify him for the record?
He's wearing, I believe, like a dark blue or navy jumpsuit with 3 silver buttons that I can see.
Your Honor, may the record reflect this witness as identified defendant in this case?
Any objections, ID?
No, Your Honor, not for the purposes of exam. Thank you.
So noted.
And this happened, the arrest happened at McDonald's, is that correct?
Correct.
Is that in Lansing?
Correct.
Ingham County?
Correct.
State of Michigan?
Yes.
And based on your knowledge with the apartment where you responded to, was that in Lansing?
Yes, it was.
Ingham County?
Yes.
State of Michigan?
Yes.
Thank you, Your Honor. That's all the questions I have.
Thank you, officer. You may be excused.
Thank you.
Call your next witness.
Thank you, Your Honor. The people called to the stand, Miss Sierra Thomas.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Yes. You can have a seat. Okay, there's a microphone that's in front of you, and the purpose of that is so that the court recording system can pick up your sound when you speak, but it does not amplify your voice in the courtroom. So I need you to speak loud and clear, okay?
Okay.
Also, if there's a yes or no question, I need you to answer yes or no versus head nods and head shakes or mm-hms and uh-hs, because we can't accurately write that into the record, okay? If you forget, we'll just ask you if that's a yes or no. If there's an objection by either of the attorneys, you'll stop speaking. I need to make a ruling on that objection, and then I'll tell you if you're allowed to give that answer or not, okay? Okay. If you could state your first and last name and then spell both.
Sierra Thomas, SIERRA THOMAS.
You can proceed.
Thank you, Anna. Ms. Thomas, let me ask you, how do you know Anthony Friesen?
We used to have a dating relationship.
Okay, and the two of you have a child in common.
Yes, we do.
How many children?
One, and I'm pregnant, so two.
Okay. And you said you used to have a dating relationship?
Yes.
And how long did that last for?
I'd have to say the dating relationship was more so consensual up until 2023.
Okay, up until 2023. And
you say you had to say it was more so what?
Consensual up until 2023.
Okay. So, Ms. Thomas, I want to take your attention before we get there. Do you see Mr. Friesen in this courtroom today?
Yes, I do.
Can you please point and identify for the record an article of clothing he's wearing?
Yes, he does have a blue shirt on and a white shirt underneath.
Okay, does he have, is his hair
Curly
dark?
hair,
Okay.
lighter skin complected.
Your Honor,
There was what color hair?
Brown
hair,
brown
okay.
curly hair.
Brown curly hair, okay. Just making sure it was not.
I didn't mean to throw you out at the last.
You're good. I'm not objecting to it. I'm not objecting to ID for the person.
So noted.
Thank you.
Thank you.
Since all three of you all have on board today.
Yeah.
Or four of you all, actually.
Yeah. So I want to take your attention to the events that happened on October 14, 2025, ma'am. Do you remember that day?
Yes.
Did you receive a text message from anyone on that day?
Yes.
And who do you believe you received a text message from?
I'm going to object, calls for speculation. If the question is who do you believe, then we're asking for speculation.
I will strike out the word belief, to be honest with you. I will follow up on who that person is in the follow-up question. So the question would be, who did you receive the text messages from?
I did receive a text message from Anthony and then also from maintenance.
Okay. Let's talk about the text message you received from Anthony. How do you know it was from Anthony?
Typical same patterns. He would text me in different numbers after blocking.
Okay. How many times have you had to block him?
Several. I have to say at least 10 times.
At least 10 times. Okay. And what was he saying in these messages?
Usually the messages would say that he loved me, he didn't mean to do what he did, and try to mend things.
Okay. At this time you received this text message, you were not in a relationship with anybody else?
No, sir.
So you only had one person you were in a relationship with?
Yes, sir.
And this is the only person you had ended the relationship with?
Yes.
And that person would be the defendant?
Yes.
So that in the whole world of 8 billion people, there could only be one person who would say that to you?
Correct.
Okay. And he said, I'm sorry, I missed, what did he say?
He would say things like he wanted to mend the relationship. I'm sorry what I did to you. I love you. I didn't mean to do that.
Okay. And that was on October 14, is that correct?
He didn't say that October 14th. However, he had texted me prior to October 14th.
Okay. What about October 14? Did you receive a text message from him?
Yes, as well as from maintenance.
Okay. All right, what did he say on October 14?
I don't quite remember what he said on October 14th, but I can fill you in on the other
as far as someone was looking for him, a
Okay.
maintenance worker was looking for him, they texted my phone, and I thought that they were texting me to complete a maintenance.
I'm just gonna
work.
object to hearsay and speculation at this point. We're into like a third party conversation with another person who's not present, not testifying, and she's
Talking about
testifying
a text message that she received? Is that
from a maintenance worker, apparently at the apartment, is what she's
Okay.
talking about.
Your Honor, I will, as an offer of proof, I'm going to try and prove that these text messages were not necessarily from a maintenance worker. This was one of the things she said as a pattern. He has a pattern of approaching her and contacting her. So that's, as an offer of proof, I would ask the judge allow this type of testimony to show that defendant has shown a pattern of contacting her using different versions or different types of people.
I'm gonna object and say it's still speculative at best, Judge, so I don't know how we're gonna,
I don't know how we're gonna get, I don't know how we're gonna get there either. This is interesting. I will reserve your objection while we figure out how he's gonna get there.
Understood.
Yes,
Thank you,
Your
Judge.
Honor. Yes, Your Honor. So let's talk about the maintenance. You received a call about maintenance. Was this an actual maintenance person to your knowledge?
He was a maintenance person, however, I do believe he was also a friend of his.
Okay, what makes you believe that?
Let me, was it a phone call or a text?
Text message.
Okay.
Okay, so let me ask you this. How do you know that it was a friend of his?
Because the person addressed who he was. I asked who it was, and they addressed him and said he delivered.
Okay, and you know the two of them to be friends?
Yes.
Okay. And you also received a text message from him on that day?
Yes.
Just to be clear, a text message from who?
Correct.
From defendant on that day?
Yes, early in the morning.
Okay, so you received text message from a person who is supposed to be maintenance, and you received a text message from defendant?
Yes, that's correct.
Okay, and one text was from a maintenance person that gave your testimony. The person who received a text as a maintenance person is a friend of defendant.
And again, I'm just gonna, Judge, I know you gave me the objection. I don't mean to keep belating the point, but I think she didn't really offer any testimony as to how she knows that the maintenance worker and my client are friends.
That was actually gonna be my question if it wasn't addressed.
And I don't, so it seems to me that at best, we're still in the land of speculation.
Right, can you get into that? Because I agree, I was gonna ask it, if not, I had it written down. How does she know that they're friends?
Correct, that was actually my next, I'm sorry it took so long. How do you know the maintenance person and the defendant were friends?
Actually, we used to work at this apartment community, and I do maintenance, and they would hang out with him.
Okay, and they would hang out with him because defendant worked as a maintenance as well?
He did definitely work for me.
Okay, and what's the name of this person?
The name of the person was Kim.
Who?
Kim.
Kim, okay. Do you know his?
Kim.
Kim, okay.
Kim, okay. Kim, do you know his last name?
I do not.
Is it a male?
Yes, I don't know much about him.
Okay. So defendant worked as a maintenance as well. Is that your testimony?
Yes.
Okay. Let's talk about the text message that you received from defendant as well. Do you remember what he said?
Typically he'd say good morning, but that morning I do not remember. I tried to block him on every number. And then after blocking him, that's when I received that message from him asking if I had seen him and do I still live at that townhouse.
Okay. How did contact from defendant and his friend make you feel? Did you feel threatened, harassed?
I did feel a little harassed because I tried to block every number and every bit of communication he had with me, or even tried to reach out in any sorts of way. And then he was doing it to other people, but it's pretty common up there.
Okay. On a typical day, how many text messages would you receive either from defendant or anybody else associated with them?
I'd have to say about 2, but typically phone calls would be like 4 to 11 a day.
Okay. And on the date of this incident on October 14, this incident occurred in Lansing, is that correct?
That is correct.
Ingham County,
Yes,
state of Michigan?
yes.
And why did you block him in the first place?
I blocked him because I did not want to hear from him. I didn't want any confrontation or anything to spiral further from what we had already.
Ms. Thomas, you're aware that there's a bond that exists between you and defendant, is that correct?
There used to be.
Okay, are you, don't worry about it.
I'm not following. She said there used to be a bond?
She said there used to be.
Okay, so
Yeah.
maybe she's unclear, okay.
Yeah.
You know, bond has many different meanings,
I
you know. Do you want to use a different word? other
Yes,
than
Your Honor.
bond?
Yes, PA 53, yes, Your Honor. To your knowledge, do you know if there's a PA 53 that exists between the two of you?
The PA 53.
A court order?
It's a court order asking him not to contact you or harass you or
Yes.
intimidate you.
Yes.
And to your knowledge, at the time of this incident, that PA 53 was still in effect, is that correct?
Yes.
Okay. And you've continuously either ignored him or having to block him, and he's had to contact you repeatedly, is that correct?
Yes.
Specifically, there were 2 or more unconsented contacts on October 14, is that correct?
Yes.
Okay. I know I asked you this, but I just want to go a little more. Have these repeated contacts to you caused you any emotional distress that you could explain to us?
It has. Typically, if I were to block him, he'd show up at my workplace or somewhere familiar that he knows I was at, and that really made me anxious at times. I didn't know when he might be there, might pop up, or what might be in his mind, how he might react or try to retaliate.
Okay. Over the course of your relationship, have you had to change jobs because of this?
Several.
How many
Several
jobs
times.
have you had to go through?
I have about 15, and that's not very low with me.
Okay. And you've had to change jobs because of repeated and continuous unconsented contacts from defendant, is that correct?
That is correct, as well as assaults. Reasons I couldn't make it to work or weren't emotionally stable to make it to work.
Okay. Your Honor, the people, that's all the questions the people have. Thank you.
Cross-examination.
Thank you. Good afternoon, ma'am. You indicated that there was you're aware that there was a no contact order in place, is that right?
That's correct.
Do you know, if you know, when that no contact order began?
I can't give you an exact date. I do believe it was sometime in 2023 after the first assault, the first police call.
Gotcha. All right. So that no contact order began sometime in 2023, and your indication is that you've not had a dating relationship with Mr. Friesen since that time. Is that accurate?
That is not accurate.
Okay. Can you tell me when the last time you had a dating relationship with Mr. Friesen was?
The last time I did have a dating relationship with him that was consensual was during that time. But however, past that was not consensual.
All right, so when you say during that time, can you give me, are you talking about 2023?
Yes, from 2022 to 2023.
Was there a period of time where, since 2023, where you've engaged in a dating relationship with Mr. Freisen, regardless of the no contact order?
Yes, but not consensually.
So you're saying that you engaged in a dating relationship with Mr. Freisen against your will?
Usually, yes.
Usually, yes. So did you ever report that you were engaging in a dating relationship with Mr. Freisen against your will? Did you ever report that to anyone?
Yes, it should be in records as of last year, I believe April.
As of April of last year, you're saying in April of 2025 or 2024?
April of last year, 2024.
2024, you filed a police report?
Yes, I actually went to the hospital. I got, there was a detective that took my statement. They also took pictures.
Okay, and then you've had contact with them since then, right?
Yes.
Has he spent the night at your apartment?
He has stayed there, yes, when he wasn't supposed to.
How often?
This is every day.
So every day, Mr. Freisen stays at your apartment against your will, and you've never reported that to anyone?
I have reported it.
Who did you report that to?
I reported it to police and sadly they have failed to do anything about it.
When did you report that?
I reported that last year, 2024 in April.
Okay, he's continued to stay at your apartment since then, right?
Since I got my apartment in August of last year, yes.
Okay. Okay, so you reported in April, you got an apartment in August, so after the report, right?
Yes,
And you're saying he's continued to stay with you since then?
that is good.
And that every time he stayed there, that was against your will?
Yes, I even expressed that to the office that I didn't want him signing a lease with me, and his name is forced on my lease.
His name is forced on your lease. Okay, you reported it in April of 2024. Have you reported it any time since then?
Yes, as of October 14th this year.
As of October 14th this year, have you, between April of 2024 and October 13th of 2025, did you ever report to police that Mr. Freisen was staying in your apartment and forcing you to engage in a dating relationship against your will? Did you ever report that?
I did not, simply because I was threatened.
I just have, you said his name was forced on your lease? How was it forced on your lease?
Me and my mother had communicated to the office that we did not want him on our lease. When she went up there, they called her frantic, they didn't want to deal with her, they didn't know what was going on. And she tried to express it. And then when we left, someone communicated to me, oh, we don't want to talk to your mom, we'll talk to you about it. I said I didn't want him on my lease.
Okay.
When I left and went back to work, and I was walking apartments, doing what I usually do at work, selling units, he was in the office and he signed my lease. I was nowhere around.
Okay. You can continue.
Thank you. You indicated, do you remember giving a statement to police on October 14th?
I do.
All right. You told police well, let me back up. You indicated that the gentleman's name, I think you said is Keen, is that right? The maintenance worker is Keen?
King, K-E-E-N.
K-E-E-M, Keen. You indicated that Keen texted you, it was a text, right?
Yeah.
He texted you and he asked you or was trying to arrange some sort of work to be done to your apartment. Is that right?
I had originally, that is incorrect. I had originally just moved
Okay.
due to the incident that happened. And I did have some maintenance request orders I put in. Maintenance did text me and I didn't know who it was at first. I asked him who it was. He addressed his name. I said maintenance, right? He said yes. So I thought he was coming to fulfill a maintenance work order that I had already put in. Then that is when he asked me about Anthony's whereabouts. I did not text back. And then he also asked me if I still live at the old address, being 4726.
Okay, so you're saying that Keem texted you initially about an old work order, correct?
No, that's what I thought he was texting me about. He asked me about Anthony's whereabouts.
That was the only question he asked you is where's Anthony?
No, he asked me 2 questions.
What was
He
the first
asked
question?
me-
I'm sorry, I'm not understanding.
That's okay. He asked me where Anthony was at.
Okay,
I never texted back because I realized he was texting me about him.
okay,
And then he also texted me and asked me if I still live at my old address.
okay. And the old address, you had had some work orders requested
I had work orders requested for the new address.
for the new address. And I don't want to ask the number, but is the old address on Duvernay Road?
Yes, it is.
The new address is not on Duvernay Road?
No,
Okay, so you had work orders for the new address on, not on Duvernay. I'm not asking you what the address is, to be clear. But you're not asking, but you're saying that you had work orders for the new address, whatever that is, but not for the Duvernay address.
to be completed, correct, that's correct.
Okay.
I may have previously put a work order in for the old address, but being my lease was canceled, it was no longer. effective.
And he as in Keem asked you where Anthony was.
Correct, I don't believe that he knew we weren't dating.
Okay. Did he, other than asking for Anthony's location, did he ask for anything else regarding Anthony?
He didn't.
And when you say that you think that he was doing this on behalf of Anthony, you don't know for sure, right? That's your estimate. That's your best guess.
I was asked if he was doing it on behalf of Anthony, but I was unsure if he was actually doing
When you
it.
say you were asked who, by who?
Police officer.
By police officer.
Correct.
And you remember giving a statement to police officers on October 14th, right?
Yes,
And you recall, and I'm assuming that when you gave your statement to police officers, you were truthful and honest with them about what was happening.
oh, yeah.
And you never told them that Keem texted you asking about Anthony's location, right?
That is correct.
All right, you didn't think that was an important detail to include?
I'm sorry, I actually did tell them, and then they told me they need liable evidence,
All right.
and they asked for it.
What do you mean by liable evidence?
They asked if.
Like, you mean reliable, like is it trustworthy evidence?
Yes,
Okay. And you didn't turn over the actual text message to him, right?
no, as I had explained prior, I had deleted phone calls, etc.
So you do not have this text yourself, correct?
I don't believe so. I could probably restore it in my iCloud if you definitely need it.
Okay, but as of right now, you don't have a copy of the text, you've never turned over a copy of the text, and you think that this was a third party acting on behalf of Anthony, but that's only a guess by you, right?
I never said that they were acting on behalf of him. It could have been, as you did ask me. However, I know maintenance did text me and they did ask about it.
Okay, now I'm confused. You're saying you never said that this was on behalf of Anthony, that's what you're saying?
Correct. You asked me if it was. I said I was unsure.
Unsure. So it could be that Anthony had nothing to do with that, right?
That's speculation, Your Honor. I'm gonna object.
I'm not asking her for I'm not asking her, thank you. It could be that Anthony had nothing to do with it, right?
Could be. However, he already texted me earlier this morning.
All right, I totally get that, right? That's a separate issue though, right? Is that a yes?
Yes.
All right, so we don't know for sure whether Anthony had anything to do with this incident regarding the maintenance, right? The best we can do is guess.
That is correct. I initially thought the maintenance worker was coming to fulfill the work order.
And the other texts, you said Anthony texted you earlier that morning, right?
Yes,
Do you know the telephone number that Anthony texted you from?
off the bat, no, it had been a text now number that he always created once I blocked him.
Okay. So it was a telephone number. The one that you're referring to is Anthony texting you from earlier that morning. That's a number that you did not initially recognize, correct?
That is correct.
What specifically did he say that morning?
Good morning, Queen.
Good
I love
morning,
you.
Queen. Is there anyone else in your life who refers to you as Queen?
No, except for my mother, and she was saying it.
Okay. Other than the good morning, Queen, was there any other text from Anthony on October 14th?
No.
I have no further questions.
Redirect.
None, Your Honor.
Thank you. You may be excused, ma'am. Any other witnesses?
No, Your Honor.
Any defense witnesses?
No, Your Honor, thank you.
Okay, you can proceed to argument.
Thank you, Your Honor. At this time, the people would like to move to have defendant bound over the one and only charge of aggravated stalking. In this case, defendant has committed continuous and unconsented contact against the victim, in this case being Sierra Thompson. In this case, the victim testified here today that she received a text message from defendant on the morning of October 14th, which had been a continuation of many contacts that she has received from defendant, all of which were consented. The victim also testified that the repeated contacts from defendant have caused her emotional distress, and she testified here today that she felt harassed by defendant. And even in addition to that, Your Honor has heard testimony here today that the victim has had to switch jobs. She has switched somewhere along the lines of 15, I can't remember the testimony, but I think it's 15 jobs because of these unconsented contacts and defendants showing up to her place of work. Your Honor has heard testimony here today, and there's been an admission of a PA 53 in this case that was entered, preventing the defendant from contacting the victim, in this case, specifically provision Q, which states that defendant is not allowed to harass, intimidate, beat, molest, wound, or stalk, threaten, or engage in other conduct that would place her in reasonable fear of bodily injury. Your Honor has heard that defendant and the victim in this case used to have a dating relationship, but they also have children, one living and one unborn. She's currently pregnant. And all these were done in violation of PA 53 that was entered before the date of this incident. And so for those reasons, Your Honor, the people would move to have defendant bound up on the only charge count.
She's pregnant, but they don't have a consensual relationship, correct? Or at least that's what her testimony.
At least that's what her testimony is. But they do have one child in common that is.
Yeah, I'm focused on the pregnancy though. Is there a CSC pending somewhere?
I have not, that was the first time I've heard that.
That's a major credibility issue here. You can't tell me that you didn't have a consensual relationship, but you sit here pregnant, and that doesn't strike me as to whether or not there was a report of a CSC or something.
At least not pending in our file.
Was there a report of a CSC?
I can go and inquire some more, just if you could give me a few minutes, Your Honor.
Yes, please.
Thank you.
Bring her back into the courtroom.
Thank you.
Mr. Palmer, do you have a jury instruction for?
For stalking? Yes, Your Honor, it's 17.25. I have a copy of it here if anyone wants to see it.
I'm pulling it up.
Yeah.
It's under assault. That's why.
Can't do that. Can't do that long division stuff. That's all you can do.
I think they're done at 3, but
Did you-
Bonnie told David, y'all need to do that. Because of what? The food. Probably after she feed it.
It's hard. I don't know.
Left the courtroom, we were able to catch her just outside.
Oh, okay.
Yeah. you want me to bring it back to the stand
Yes,
here?
please. Ma'am, if you can retake the stand, we just have another follow-up question. But remember, you're still under oath, okay?
Yeah.
Okay.
Okay, so you stated something along the lines of unconsented, you had an unconsented relationship with defendant, is that correct?
Yes.
You're currently pregnant, is
I
that
am.
correct? And is your pregnancy a result of unconsented sexual act?
It's a result of unconsented relationship, however, not consented sex. I figure I get used to the situation.
Okay. The date you got pregnant with your current pregnancy, was that because, did you consent on that date?
I did.
Okay. Has there been a time in your relationship with defendant where you had unconsented sex?
Yes.
Okay. When was this?
Usually after arguments that he would throw, physical fights.
Okay. Do you remember, was this in your first or did this result in pregnancy?
Judge, I'm just gonna object at this point, because I think now we're going way out. If maybe I misunderstood the court, but there was, as I understood it, we were calling the witness for the purposes of a credibility issue.
Correct. I just
And
wanted
now
to
we're
know
just
about-
we're kind of almost on like a fishing expedition.
Yeah, we don't
about-
need to get too deep into
Okay.
that. I just wanted to understand the comment that she had been in, she termed it a non-consensual relationship since 2023. But then there's an indication that she's currently pregnant. About how far along, ma'am?
About 3 months.
3 months pregnant. But that was, and it wasn't clear if that was consensual. That's what I want to
Okay.
understand.
Okay, I understand. And so,
But I think it's.
So she's saying that, so you're saying, ma'am, just so I'm clear, because there was a portion of your statement I didn't hear. You said that you were not in a consensual relationship when this happened, but the act that caused you to be pregnant was consensual?
Yes, I have been in a situation like this prior, and it's just to protect your safety.
I don't know what you mean. You've been in a situation like this. I don't know what you mean.
I had been sexually assaulted prior, and to protect my safety, I had to perform acts. So my relationship was not consensual. However, I did consent to the sexual activity because I didn't want to start arguments, physical fights, and endanger myself.
That's, for the record, that's not consensual, but I understand what you're saying. Okay.
Yes.
Any cross-examine based on my question?
No, Your Honor.
no, Your Honor.
Thank you. You can be excused, ma'am.
Do I have to come back?
You do not have to come
Okay,
back.
Thank you.
Thank you, Anna, that's the.
Okay, thank you.
Yeah.
Mr. Palmer.
Thank you, Your Honor. Obviously, I'm asking the court to not bind this over on stalking, on an aggravated stalking basis for a couple of reasons. First of all, I'm just gonna say this and get it out of the way. Might this be a PA 53 violation? Might we have a ton of evidence of that? Maybe. I'm not admitting to that, but I'm just not gonna address it because I don't think technically that's before the court today. My concern in this particular case is, first of all, I will point out the way this case is charged, it's charged October 14th of 2025. It is not charged in a window. It's not, for example, from August 1st to October 1st or some multiple month window, as I normally see stalking cases charged. This is contact that is specific to October 14th. And I think the court's already sort of raised it, but I think that there is at least a serious issue with regards to this particular witness's credibility. This particular witness has said some somewhat outlandish things under oath today. She has testified that she was in a non-consensual relationship. We don't really have a lot more detail than that, but apparently this non-consensual relationship lasted from roughly, as I understood the testimony at least, from April of 2024 until October of 2025, despite the fact that she routinely, it sounds like from her own testimony, routinely was going out, going to work, had access to a cell phone, apparently had access to a vehicle, all of these things, and continued to sort of return to that situation. There were, if this was truly an unconsented relationship, I've never actually heard that term before, but if this was truly an unconsented relationship, there were obviously many, many opportunities for her to reach out and seek assistance or leave or whatever the issue is. The elements of this are first that the defendant committed 2 or more willful, separate, and non-continuous acts of unconsented contact. And then it goes on to talk about, as the court I'm sure is aware, it goes on to talk about all of the things that unconsented contact may indicate. Then second, that the contact would cause a reasonable individual to suffer emotional distress. Third, that the contact actually did cause, in this case, Sierra Thomas to suffer emotional distress. Fourth, that the contact would cause a reasonable individual to feel terrorized, frightened, intimidated, threatened, harassed, or molested. And fifth, that the contact actually did cause the person to feel all those things. And then finally, sixth, that at least one act of the unconsented contact in this particular case was against the condition of a court order. I don't know how we get to 2 unconsented contacts on October 14th. At best, we have 1. Because the way this complaint is written, it is October 14th specific. So we look at that particular day, and the 2 contacts that the people have put up are one by Sierra Thomas's own testimony, 1 text that she believes came from Mr. Freisen, where he said something to the effect of "Good morning, Queen," which I don't know. First of all, even if that's true, I don't know that that causes a reasonable individual to suffer emotional distress, but
it could.
It could, I guess.
If you don't want to be a queen, it could. Or if you don't want to be contacted and it happens all the time, that could cause you to be annoyed.
I totally agree with the court. I agree with that. But the other contact on that day, how we suggest that that's from Mr. Freisen, I have no idea.
She said she doesn't suggest. I don't think she necessarily suggested. I think that's the concern I have myself, is that her statement was she believed it was this person named Keem, and that she doesn't believe that he was aware that she and the defendant were not in a relationship.
And also, according to her testimony, Keem asked her where Anthony was. Why would Anthony text her and ask where he was? That doesn't make any sense. And so I'm suggesting to the court that the way this is charged, at least as to October 14th, there have not been 2 or more unconsented contacts. At best, we have a violation of a court order, which is Judge Aquilina's problem, and we'll deal with that separately. But at best, we have a violation of the court order. We don't get past the first element. And so I'm asking that this case be dismissed.
Mr. Billabay.
Your Honor, as far as the range, as counsel is bringing up, this issue could easily be replicated by simply amending charges and including the range of the dates. But there's no question here to the uncontroverted testimony that the victim has presented here today, and one including having to change her job 15 times. And that, to the people's position, that is more than sufficient consented contact.
Mr. Billabay, are you making a motion to amend the range?
Correct, Your Honor.
What do you make it to amend it to what?
So at this time, we will make a motion to amend the dates to include, let me look at my police report, Your Honor. The contacts that started in 2000. Sorry, Your Honor.
Well, she testified that he texted the day before.
Correct.
October 13, 2025.
Correct. I was trying to go further than that.
We're not going back to 2000 anything.
Thank
you.
We
need 2 or more.
Thank you, Honor, and that would be sufficient. So we would amend the complaint to include from October 13, 2025 to October 14, 2025, Your Honor.
Thank you. I think that clears the issue 100% for me, because she testified today, she being Miss Sierra Thomas testified that on or about October 13th and 14th, that she, at the time living in the city of Lansing, Ingham County, not clear if she's at the Duvernay address, but the officer did testify to report at an office, an apartment complex on Duvernay, and being dispatched there because a caller, and being dispatched by the property owner because the caller was looking for his former girlfriend. But none, and also I should say that the officer, that being Officer Owen Rogan, said that he did look into the defendant's cell phone when he took him into custody, and he did see evidence of calls and text messages to the victim. And then we also have testimony from Miss Thomas, and she testified that she received text messages. She said that she typically receives anywhere between 4 to 11 text messages or attempted calls from the defendant. She said that she has blocked him at least 10 times, but specifically on the 13th, she said she did receive a text message from him saying that I love you, he apologized for whatever he had done, and that he would try to make amends. And then she says that she texted her on the 14th, and that the 14th text message was a text message indicating, "Good morning, Queen, I love you," and that out of the 8 billion people in the world, no one else would have texted her except her mother to say, "Good morning, Queen," and her mother was living with her or staying with her at the time. Based on the nature of the relationship, which is very unclear, I think the issue that's still glaring, obviously, is what the nature of the relationship was, because I think that is where it gets a little weak for the prosecution, is what exactly was the relationship. And I'm not saying that there was a situation where the victim or the alleged victim felt like she needed to concede to certain actions for her safety. My understanding is that there is another matter pending where she's a victim.
It's a case that way predates this. That's pending up at Judge Aquilina's court. So I think
all I'm saying is that there could be a history or a pattern. I don't know.
Oh,
That's something
yeah.
that needs to be flushed out,
Correct.
I believe, at trial, as to whether or not there was a pattern of behavior that would make it reasonable to believe that Ms. Thomas felt so unsafe that she would need to concede her body for protection. And again, she testified that she is the victim of sexual assault and that she believes that's the best way to protect herself. So right, wrong, or indifferent, that's the testimony she's given the court. I have nothing to before me that to dispute that that's not her mindset. But I do have her testimony that she felt that she was distressed and she was bothered, and that obviously she has a history of blocking all of these numbers that she believes is associated with the defendant. And again, it's more than mere suspicion that it's the defendant, only because I got Officer Rogas saying he went through his phone and he saw calls and text messages to the victim. So that ties them right there. There's more than one, or there's 2 or more separate and willful unconsented contacts to satisfy that. There's also at the time a valid court order because there was a no contact order. He wasn't to have contact directly or indirectly with the protected party, and that order well, it can't be this order, because this order was signed on the 15th. So it must be, is there a no contact order in the circuit court?
Yep.
It was arraigned on October 15th. Then obviously it couldn't be this order, because this would be the order that stemmed from the aggravated stalking. So it's got to be another valid court order.
Correct. You and I have it here, just. I just had it, Your Honor, it went away, sorry. Would Your Honor want to see it?
I can take judicial notice. What's going on?
It does exist, Your Honor. This is on April 25th, 2024. And it is signed by magistrate. I apologize, Your Honor.
Is the magistrate no more?
I can't read that, yeah. It doesn't end there.
It's probably magistrate no more.
Judge, I'll just say for the record, as an officer of the court, as much as I want to object, I don't know what possible basis I would have to suggest that there's not a no contact
Right.
order. I know
We
there
know
is.
we know there is too. We just want to know what case.
Judge, can I approach? I think I have it.
Okay, thank you. Of course, this is an issue that is not in the best interest of the prosecution, because obviously this no contact order was from 2024, and then now we have a pregnancy that's not necessarily from a non-consensual relationship, but I do, or interaction, I should say. I do see, no contact order here. It says the bond was set by Judge Buchanan on this one.
I think that's
Or at least
correct.
amended. So there was at the time a valid no contact order in place, which is the element needed to make this an aggravated stalking. So the court will bind this matter over to the circuit court for further prosecution. Again, this is just a preliminary examination. This is not a trial. You only need more than mere suspicion that the alleged actions took place. They don't have to prove each element beyond a reasonable doubt here, okay? So the matter will go over to the circuit court for a bind over date of November 12th. That's the date the circuit court is going to receive the file from the district court. It's not a date that you, Mr. Bryson, needs to appear in the circuit court, okay? Your next court date will be made after that, and your attorneys will be made aware of your next court date, okay?
Thank you, Judge.
Any additional matters for the record?
No, Your Honor.
No, Your Honor.
You're all set. That's that. And then can you bring up Jones?
I thought he was gonna waive his appearance.
Or are you gonna raise it? I think it was for bond.
If he's still here, I'll.
Okay.
Yeah, he wanted to address bond, I thought.
Yeah, if he's gone,
You
I'll.
can't waive appearance for that, so I gotta tell you what your bond is if I'm gonna change it, but we'll see. Are we ready?
Yes,
Yes,
Your
Your
Honor.
Honor.
Okay. On the record in the matter of the people of the state of Michigan versus Andrew Jones, 25-02542, appearance, please.
Jeffrey Billabille on behalf of the people.
Well, good afternoon, Your Honor. Attorney Derek Esther, also public defender on behalf of Mr. Jones is in the courtroom, standing to my right.
So Mr. Jones was scheduled today for a preliminary examination, but it's continued for a drug court assessment. And counsel, you wanted to address bond.
Yes, Your Honor. Your Honor, I've talked with Mr. Jones several times about bond. He understands that even though the court was to grant him a bond that he could post or a PR bond, that he likely wouldn't get out because he is on a parole hold for Michigan Department of Corrections. He's advised me he would like to get the bond so that it would, in effect, make MDOC go ahead and take action on the parole violation. The understanding is that they're more than likely going to end up resolving his parole violation with whatever happens in this case. In this case, as the court points out, we made a drug court referral. We've adjourned a couple of times, but I think we're almost going to have an answer soon because they finished my understanding, they finished the assessment on Monday or Tuesday when they interviewed him, and they're just reviewing the stuff to make a decision. He has been getting therapy through CMH CATS at the jail, and has a therapist outside of the jail that he would be seeing. He also is getting services through Pathways to Care. Mr. Sterling's helping him and going to help him once he gets out. If he does get out, trying to get a place to live and get a job or work at Tech and try to get a trade. He is more than willing to have a GPS tether placed on him if he is released. He is on Medicaid and food stamps, he advised me, so he isn't indigent, would qualify for grant money. If he gets out, he would have to stay at the rescue mission or outreach, but he does have a phone number that is operational, that his phone was placed in his property, that once if he does get out, we'll be able to use that phone. If the court does agree to any type of bond that he can post for a PR bond that he could get out, I would ask the court to include in the bond conditions that he continue to get services through CMH. They just recently got him back on his medications. He's taken numerous psychotropic medications. He's diagnosed with major depression disorder, PTSD, schizoaffective disorder, multiple personality disorder, according to him. And he's been in jail for the violation for at least 71 days straight. Based on that information is provided, the court asked the court to consider a PR bond with GPS tether and appropriate bond conditions.
The people will leave it up to the court's discretion.
Okay, so he's saying that the Lansing Rescue Mission under March.
The city rescue mission over on Kalamazoo, they used to be on Mission.
Oh, they moved. And whose address is 1320 Warwick?
That valid mailing address? That's his sister's address, Your Honor, but it could
It's a
be
mail.
a valid mailing address.
Okay, and what about your phone number?
The phone number he provided me, Your Honor, do you know it? To visit for it?
517-303-0908.
That's an active number?
Yes, it is.
I'll amend your bond to 500 personal recognizance with GPS tether.
Thank you, ma'am.
All other bond conditions, including your treatment through CMH, is to continue, okay?
Yes, ma'am.
And then your next court date, I believe, is set for December 11th.
I'll make sure to be here.
Very good. Any additional matters for the record?
Nothing from the people, Your Honor.
No, Your Honor, thank you.
Thank you. You're all set.
Yeah, so if they let you out, if they brought the hold in, let me know. Okay. You know,